Right, good morning, everyone. We are reconvening the Court of Appeal for Civil Appeal number 11 of 2021, the Corporation of Hamilton against the Attorney General and the Governor. The appearances are as before, and the proceedings are taken before my Lord the President, Sir Christopher Clark, Mr. Justice of Appeal Jeffrey Bell, and Justice of Appeal Dame Elizabeth Gloucester.
I'm sorry we've been slightly delayed, but the reason it will not surprise you to learn is because we have been reading the note provided by Mr. Myers and the skeleton provided by Mr. Duncan in such time as has been available for that purpose. The first is shorter than the second. Although we have read the second, I don't think you should assume that we have necessarily taken it all in the 7 minutes available for that purpose.
Thank you, my lord.
My lord, was the skeleton, a new skeleton, was it distributed today?
Yes, at about 1 minute to 9 o'clock Bermuda time. Have you got it?
No.
So Jeffrey, excuse me if you haven't got it, but there are 2 email addresses that you have that it was
Yes,
sent.
well, I'm sorry, I will look again. I didn't, I possibly should have looked more carefully, but I have recently looked at my emails and I haven't seen it, but before saying I haven't got it, if I may check again, and I do apologize.
No.
If I didn't see it. I wonder whether Mr. Myers has got it.
I actually did receive it, Sir Jeffrey.
Oh, you did? Oh,
I did,
well,
yes. Just now.
I'll look immediately.
Mr. Myers, perhaps you can confirm the 2 email addresses I used for Jeffrey, I cut and pasted from your emails. So
Yeah.
hopefully,
Blackstone Chambers or AOL. Yes, that should be there. I'm sorry, I thought I looked at my emails, but that should not delay matters. But my lord,
Those are right.
Yeah, my lord, with your permission, there are, and not wishing to delay matters further, and certainly for no longer than 5 minutes between myself and Mr. Myers, I wonder if we could quickly address 2 issues in response to your questions yesterday, and that I think, if answered very briefly now, will guide today's proceedings better than they could be.
Okay.
Thank you. The first is on the central issue of control of the corporation's property by the government. And yesterday, the court identified 3 classes of case in descending order of seriousness. We have acquisition, and then control, and thirdly, cases where there's no interference with the property rights at all. And that we believe, this is leading up to the relationship between sections 1 and 13, which is a matter that Mr. Myers deals with as well. As a matter of law, we think that is the right characterization. And we say also that which of those categories a particular government action falls into is a matter of fact and degree. And we want to be clear that our case here is that the level of control in this case is of the most invasive kind. In fact, we would say it's difficult to imagine greater control over a corporation's property than de facto the power to determine whether and on what terms it is alienated. Secondly, the power
de facto power to determine
the power to, firstly, the power to determine whether and on what terms it is alienated.
Do you mean transferred?
Transferred, yes.
Yeah.
Secondly, the power to require it to be given over to the government without compensation. I'll put in this note, my lord, if I may. It's almost over. And thirdly, the power to direct any particular use of the property, including the application of funds, and to appropriate the fruits of any such use. I'll submit this shortly. Now, what we say is this, that none of the fundamental elements of property ownership, in short, still reside de facto with the corporation. It holds them in law, but not in any meaningful sense of fact. And coming to the point, we say, that is why we say that it is both a deprivation under Section 1 and a compulsory acquisition under Section 13. And that is the point I just want to absolutely to stress, because what greater control could there be? We had the factual argument yesterday, so I will not spend any more time, but we thought that this was worth recapping as a headline point this morning, and I'll submit that note. And then Mr. Myers, I think, also submitted, but you've already perhaps read his submission.
Yes.
My lord, do you need me to go through it, or how would you like me to proceed?
Well, you want to start with the rule of law argument, do you?
I thought I was just looking at the issue that you had raised yesterday during the course of the discussion.
Oh, I'm so sorry. I'm so sorry. I thought it was Mr. Duncan speaking.
No,
I'm
no.
so sorry. No, I'm sorry. I wasn't looking.
That's all right.
No, I don't think you need. I think we have followed what you say.
Okay. Thank you, madam.
Which is broadly speaking that if the government, if there is a compulsory acquisition within the meaning of Section 13, and the government satisfies the conditions for taking possession without compensation, the person whose property is affected can't get round that by relying on Section 1.
Mm-hmm.
That's item number 1. And if the position is that there's been a clear compulsory acquisition and the person affected falls within one of the exceptions, so it can't succeed under Section 13, the person affected can't be better off by relying on 1. That's what it amounts to.
Exactly, my lord.
Well, that sounds quite sensible.
Thank you, my lord. May I just introduce a tiny item of housekeeping? Unfortunately, today is my 4-day COVID test, as I was in England last week. So at some point today, they say it has to be between 12 and 1. But at some point, when that's convenient to the court, today I'm going to have to run away and get that done, if that's all right. I try to get out of it, but they tell me.
Well, we would normally adjourn at 12 o'clock your time.
I will run away then, but I'm just saying it may be that I'm a little late or a little early, you know, because there's a line and that sort of thing. I'm just drawing it to your attention, my lord.
Yes. Okay, thank you.
Thank you, my lord.
Right, Mr. Duncan, I think it's your turn.
Thank you, my lord. Lord, there are a number of points to deal with. Section 1 and its independent enforceability. Section 1 and the impact of Jamaicans for justice. In fact, there's a quartet of cases that my friends rely upon.
Yeah.
Rule of law point, Section 9, and the constraints within the rule of law with regard to Section 7AA. So I'm going to start with the Section 1 point.
Yeah.
My lord, if you can have our skeleton argument of the 17th of September, the first one, alongside, I'm going to try and take us through some points with respect to this assertion regarding the independent enforceability of Section 1. I will be referring to paragraphs 5 through 45 of the skeleton argument as I go through, but the starting point I begin with is this. With respect to the independent enforceability of Section 1, it's not loose language to say that the appellants are trying to draw crooked lines straight. And the reality is that there is no language they can borrow that will change the fact that, with the greatest of respect, this court is bound by the cases of Olivier, Great Bay in the Court of Appeal, Inchcup, and Ferguson. And even if there is the view from this court that the decision on Section 1 in Olivier was obiter and was not ratio, it has been endorsed in ratio in subsequent Privy Council cases, which have been referred to by this court. So the first question that has been posed by the appellants is that Section 1 does not contain a provision that prohibits them from enforcement. And the first case we need to look at is Olivier. And the case of Olivier is found at tab 21 of the bundle.
Yes.
This court has been taken to the case already, so I will go straight to the parts upon which I rely. The court is aware that this is an appeal from the Malta Court of Appeal, and the Maltese constitution as it then was identical in material parts to the Bermuda Constitution. On page 127, paragraph B, the court states that the case raises important questions as to whether there were contraventions of the provisions of the Malta Constitution Ordering Council 1961, and in particular whether the respondent's rights under section 13 or 14 or under both those sections were infringed. Section 16 provided for the enforcement provisions, which gave certain fundamental rights and freedoms to individuals. Section 16, 1 and 2 were in the following terms. And the important issue there is that at the commencement of section 16, it reads, any person who alleges that any of the provisions of this part of the order has been or is likely to be contravened. The important words are this part of the order. And so when considering our section 15 equivalent, what we're looking at is that our section 15 refers to the foregoing provisions, which includes the much vexed section 1. When we go down to paragraph G on that page, we see it is to be observed that an application may be made by a person who alleges that any of the provisions referred to has been or is likely to be contravened in relation to him. The respondent so alleged, he alleged that the provisions of sections 13 and 14 were being contravened and that they were so contravened in relation to him. So what we have is to translate the equivalent of our section 15 referring to contraventions of provisions within our sections 2 to 14. And in Malta, they're referring to their section 16, referring to contravention of provisions of the Bill of Rights in paragraphs 13 and 14. But the important point is that the enforcement provision includes section 16, and it includes the equivalent of section 1, which is section 5, as you see over the page. Over the page.
I'm sorry, I'm getting a little lost.
Let me take it.
Enforcement provision is section 16.
Right.
Yes.
Section 16 is referring to the provisions in the Bill of Rights, which includes 13 and 14, that were the subject of the dispute in the case.
Yes.
The equivalent of our section 1 is their section 5, which is over the page.
Right. Yes.
And you'll see that the section 5 commences with the words, whereas every person, and then you'll see A includes the protection of law.
So just a minute. When section 16 deals with any of the provisions of this part of this order, that doesn't include section 5, does it?
Yes, it does, my lord.
It does include. These things are terribly difficult without having the Constitution in front of one, because minor differences, apparent differences, may make all the difference. Because if it does include 5, it would mean that any person who alleges that any of the provisions of 5 is likely to be contravened can bring a claim.
Right. No, it doesn't look like it does include 5, because it's part 2 and section 5 is not under a part 2. So that's right, or it doesn't include 5.
Sorry, say that again more slowly.
It does not include 5.
Right. So this part of this order does not include 5.
Yes, that's correct.
That's what I thought you to be saying before. Right, okay.
So that is the, what I'm looking for, my lord, is a reference to where 16, 13, and 14 are described in the Constitution as under a separate part heading, but it doesn't seem to identify it.
Right.
It doesn't identify it.
No, okay.
So, my lord, this is the case that caused the genesis of the dispute between a number of jurisdictions regarding whether Section 1 is enforceable. We will see later on that the Malta Constitution was described as being similar to the Bermuda Constitution by Lord Hoffman in a number of cases. The next case.
Mr. Duncan, can I just draw your attention? Yeah, I mean, it was a point that I made yesterday in relation to a different provision, but in the middle of section 5, it refers to the provisions of this part of this order shall have effect, so on and so forth, which differs from the language in our section 1, which refers expressly to the subsequent provisions.
Right.
Does any point turn on that? Does that make your case stronger?
It would, because if in our section 1, the references to subsequent provisions, it implies that it doesn't refer to the section itself, and the section itself is not enforceable. Whereas if section 5 is referring to provisions in the part of this order, it's assuming that those provisions are within the provision where section 5 is.
Yeah.
So the next case that follows in sequence is Great Bay in the Court of Appeal, not in the Privy Council.
No. Here we have Olivier, which was interpreted in Farias as Lord Morris saying that there was an independent right, and has been interpreted in other cases as him saying that there wasn't, and in any event is obiter. Is that right?
Olivier, I think we determined yesterday, may have been obiter because it wasn't resolving the question on section 1, but it's subsequently been approved in Privy Council cases that are indeed binding on this court. So we have a situation where if you look at Olivier in its original format, it could be interpreted as being obiter, but now it has the force of ratio based on a number of cases like Campbell, Rodriguez, and Newbold, which have made that separation and distinction more concrete.
I'm slightly confused, I'm afraid, going back to the thing we were looking at earlier. If you get the question we were looking at, if you go to paragraph 5, at page 128 in Olivier, it says, whereas every person is entitled to various fundamental rights, and then goes on to say the provisions of this part of this order shall have effect for the purpose of affording protection to the said rights and freedoms. That suggests that the provisions which dealt with the specific rights and freedoms were part of the same part of the order as section 5 was. Whereas a moment ago, if you go back to the previous page, in relation to section 16, which said any person who alleges that any of the provisions of this part of the order has been contravened, you tell me that that did not include section 5.
Well, it doesn't. We've got no separate distinction between the first provision, section 5, which is in part 2, and section 16. There's no clear statement because we don't have the whole constitution as to whether or not
this is a section 16 either is or is not in the same part in part 2.
Lord, I agree, and I'm looking
Well,
to
it looks
see.
to me as if it is, although you told me a moment ago that it wasn't.
Well, it's very difficult to tell from the case. I'm looking at page 129 now, and it reads, actually the foot of page 128, the provisions of part 2 are to have effect for the purpose of protecting the fundamental rights and freedoms, and it goes over the page.
And it says
And it says the succeeding sections show that the promise scheme was followed. The respective succeeding sections proceed in the first place to give protection for one of the fundamental rights.
Look at the end, first full paragraph on 129, the last line, last sentence. A perusal of section 6, 7, 8, 9, 10, 11, and 12, which need not for present purposes be set out, illustrates how the scheme and the scope of part 2 were unfolded, and then goes on to 13 and 14. It looks to me almost certain from that that part 2 included sections 5 and down to 13 and 14.
What I think the best we can do is infer whether they are included.
Well, the best thing we can do is to find the Malta Constitution Order in Council 1961.
I actually have it in front of me, my lord, if it helps.
Right. And what is the answer?
The answer is section 5 and section 16 are both in part 2.
Right.
Yes, thank you.
That's the answer. I
Thank
can
you.
send this into the court right now, actually, if you like.
Okay.
Yeah.
So the question then follows, what does that mean? One would have thought that that means that if they are contained within the same part, then Section 5 would be independently enforceable.
Yes.
But the reality is that Lord Morris has determined that it wasn't independently enforceable. He still described it as a preamble, commencing with the words, whereas, and you can see page 128 is that there's another reference, but the best reference is at page 128. Paragraph E, it is to be noted that the section begins with the word whereas. Though the section must be given such declaratory force as it independently possesses, it would appear in the main to be of the nature of a preamble. It is an introduction to and a sense of prefatory or explanatory note in regard to the sections which are to follow. It is a declaration of entitlement, coupled, however, with a declaration that though every person in Malta is entitled to the fundamental rights and freedoms of the individual as specified, yet such entitlement is subject to respect for the rights and freedoms of others and for the public interest. The section appears to proceed by way of explanation of the scheme of the succeeding sections. And so it's not the succeeding part, it's the succeeding sections. So that is the first case. And
Well, yes, for the trial, as we all know, the section, what Lord Morris says, creates as many problems as it solves. It's A, obiter, it B, recognizes that the section must be given such declaratory force as it possesses, but is in the main of the nature of a preamble, but also says that it's a declaration of entitlement. A declaration of entitlement which doesn't give you an entitlement seems rather odd.
it is, but there are reasons for that that we'll come to, my lord, in particular,
Right.
in relation to the subsequent sections contain provisions that balance the rights of the applicant and of the government. Section 1 loosely has those provisions, but really not in the same way as the subsequent sections. And so that's one of the concerns one would have, and I'll come to that with the separate enforceability of Section 1. But the next case that we should give some attention to is Great Bay in the Court of Appeal.
Just before we get there, you tell us that we are bound by Great Bay and Inchcoop and Ferguson.
Well, maybe not Great Bay, my lord. Maybe at the point of Great Bay, you then had the position of Ferris and Great Bay. But once you get to Inchcup, there was a choice to be made by this court, and the court made a choice. And then once you get to Ferguson, effectively, there's a double down on the choice that was made in Inchcup by this court.
Well, wait a moment. You say that once you got to Inchcup, there was a choice.
Between Great Bay and Ferris.
Well, if Great Bay was obiter and Ferris was ratio, there wasn't a choice to be made.
Great Bay in the Court of Appeal was not obiter. Great Bay in the Privy Council was obiter.
But but that's not right. You say Great Bay was not obiter in the Court of Appeal, But as
Right.
I understand, but then the matter went to the Privy Council, which
Didn't
said that
opine on the point. They upheld the appeal. Mr. Myers is here, who was involved in the case, but they upheld the appeal and passed no comment, certainly no adverse comment on the finding of the, and I'll take the court through all those cases.
There was no obiter statement in the Privy Council on Great Bay. They didn't deal with the point.
They didn't deal with the point. But what they did comment on the point. Lord Hoffman did comment on the point and declined to make a finding on the point. But the Court of Appeal did make a finding on the point. And our submission is that at the point at which we arrived at the case of Inchcup, this court had a choice between Ferris and Great Bay. And this court, based upon...
Wait a minute. Had the Privy Council decision been given before or after Inchcup?
Before.
Yes.
Right. But I thought there was an exception from the principle of ratio if the Court of Appeal reaches the decision and subsequently the Privy Council says that question didn't arise for determination in the light of what we find.
Lord, we could go to Young and Bristol Aeroplane Company, but let me just set out what our position is first, and that's an interesting thought from my lord, because certainly the Court of Appeal in Ferguson didn't take that position, but our position is this.
Well, that may have been a mistake.
Our position is this, and we'll come to that, whether it's a mistake, just so that I have it clearly before the court. We have the decision in Ferris, which is subject to some criticism anyway, that was leveled, I think, in Great Bay and certainly by the Chief Justice in this case, with respect to the fact that it was only signed by 2 judges. So we have the case of Ferris. Next, we have the case of Great Bay in the Court of Appeal, which followed Olivier. We have the Privy Council in Great Bay that makes no finding on the Section 1 point, but rejects the appeal, but doesn't interfere with the decision on Section 1 below. We then have the case of Inchcup, where the question of enforceability of Section 1 was squarely before the court. And the cases of Ferris and Great Bay were then available for the court to choose between, and the court chose to follow Olivier and Great Bay. Subsequently, in this court, we've had the case of Ferguson. And we'll come to that because my Lord Justice Bell was involved in the case of Ferguson on the panel. My learned friend, Mr. Myers, appeared in the case of Ferguson before the Court of Appeal, and my learned friend, Miss Sadler Best, appeared for the government in the case of Ferguson before the Court of Appeal. Now, at the end of the judgment, I think it's paragraph 76, there is a reference to the fact that the independent enforceability of Section 1 is rejected. But I am instructed by Ms. Sadler Best that the court had before it all of the usual suspect cases, including Campbell Rodriguez, Newbold, Great Bay. They were all before the court.
This is in Ferguson.
In Ferguson, they were all before the court. And I'll go through the list. And so what we have now is a situation where on 2 subsequent occasions, this court has rejected the independent enforceability of Section 1 based on the Ferris case. So we say respectfully that this is not a question that is open for this court on this occasion, because there are 2 previous cases before this court that have come to the decision that Section 1 is not enforceable. So, Lord, if I can now go to Great Bay at tab 11 and try and make good that point that I have just made. So Great Bay in the Court of Appeal is at tab 11.
Yes.
Now, can I take you to page 17, where, well, it actually starts page 16, half the way down. You can see that there's a reference, the way Section 1 of the Bermuda Constitution is expressed is, in my view, clearer than terminology of Section 5 of Part 2 of the Constitution of Malta, set out and discussed by Lord Morris in Olivier.
I'm so sorry, which tab did you say?
Tab 11, page 16.
Oh, yes, thank you.
Half the way down the page. So this is Great Bay in the Court of Appeal. You can see there's a reference to Olivier, and there's a reference to Section 5. Over the page on page 17, the court notes that the section begins with the word whereas, and the words that we've just gleaned from the case are referred to as a declaration of entitlement, coupled, however, with a declaration with respect to the rights enjoyed by each person. The section appears to proceed by way of explanation of the scheme of the succeeding sections, and it repeats the paragraph, my lord, that you just read with respect to sections 6, 7, 8, and 9, and then first to sections 13. But then we start the material portions of the judgment, page 18. Can I ask the court to read on page 18 from Societe down to the end of the page?
Yes.
So the court in this case declined to find that Section 1 was separately enforceable for the purposes of determining whether or not Section 1C, a deprivation of property application with respect to the McDonald's restaurant application for license, would be granted.
There's a problem about this judgment, isn't there? Because what Justice Kempster says is, in the penultimate paragraph on page 18, difficult as it is to follow the reasoning, this decision might well bind us, but for the higher authority of the Privy Council in Olivier. If you have a ratio decision of the Court of Appeal, prima facie, subsequent courts of appeal are bound by the previous ratio decision of the Court of Appeal, notwithstanding an obiter observation in the Privy Council.
My Lord, that
It's just a
then,
mistake.
that then gets us into rather uncomfortable territory, because one then has to question the validity of the decision in Malpas, because it was only signed by 2 justices.
I don't really follow that point, Mr. Duncan, because, I mean, even assuming that the 3rd justice dissented, the judgment of the 2 would be the judgment of the majority, and that would be the judgment of the court.
Well, I'm not sure it's that straightforward based upon the
Nothing in this case is
the
straightforward.
provisions, sorry, based upon the provisions of the Court of Appeal Act that I think I referred to
Yes,
in our skeleton argument.
section 3.
Sorry, Lord,
Section
yes.
3.
Let me just find those provisions in our skeleton argument. In our skeleton argument, it's paragraph 33. And I think this was also reflected upon by the Chief Justice in.
We commented on it.
Yes. So section 3.2 of the 1964 Act.
But it's not suggested that 3 justices didn't sit. The only issue is whether 3 justices signed the award.
We don't know is the answer to that.
Well, it's never said that 3 justices didn't sit.
Well, my Lord, all I could say is we don't know. All we know is that 2 justices signed the judgment. So, my Lord, the alternative point to that is this. We have a number of Privy Council cases that do bind this court.
Yes.
That do say that section 1 of our Constitution, whether it be based upon Olivier or their own interpretation, should be considered as a preamble and not separately enforceable. And I'll take the court to those cases. I still do.
I quite follow that. Just before, let's take one thing at a time. Forget about the Privy Council for the moment. What I think you say is that even if the position is that in Great Bay, the court should have regarded itself as bound by ferries. Nonetheless, the Court of Appeal decided in Great Bay, Inchcup and Ferguson that section 1 did not give an independent right. And since the court has on more than one occasion decided to not to follow ferries, the decision as to which of 2 inconsistent decisions of the Court of Appeal should be followed has been made, and once made, it's made forever.
That's correct.
Yeah.
And this court has the comfort that that decision has been endorsed by the Privy Council on a number of occasions.
Yes and no. I'll explain what I mean to that when you show us through the Privy Council decisions.
So going in sequence, we then go to Great Bay in the Privy Council.
Yes.
That is at tab 54 D.
Can I give notice for future hearings that it would be terribly convenient if the authorities were assembled in chronological order? Which they are
Yes,
not.
I'm not going to shirk from accepting responsibility, even though my learned friend, Mr. Myers, and I were involved in the compilation of the pundit. I'm not going to shirk from that.
Sorry, did you say 54?
54.
54.
54D.
Oh, yes, I see. This is the one that was added. Yes. Yeah.
So, Lord, I can ask you, going straight to the relevant provisions, section, page 582.
Yes.
Mr. Deal, who has now left us, to whom their lordships are indebted, referred to the important difference in language between the Bermuda and Mauritius constitutions with respect to section 1. Whereas every person in Bermuda is entitled to fundamental rights and freedoms of the individual, that is to say, and the introductory word whereas is more indicative of a preamble to later operative words than a separate enactment. In Olivier, the Privy Council considered the Constitution of Malta, in which the general statement of rights in section 5 also began with the words whereas every person in Malta. In giving the judgment of the board, Lord Morris of North said at page 128, and then it refers to what we've already mentioned. And then it says, it was these remarks which the Court of Appeal followed in the present case in holding that section 1 as a preamble was an aid to the construction of section 13, but not separately enforceable. It pointed out that the phrase, the subsequent provisions of this chapter, which appears in section 1 of the Constitution of Bermuda, did not appear in section 3 of the Constitution of Mauritius. On the other hand, Mr. Deal has drawn their lordship's attention to other Commonwealth cases in which a different view was taken of the construction of the word whereas, and there's a reference there to a number of cases. And then at paragraph H, it is, however, unnecessary for their lordships to decide in the present case whether the general statement in section 1 of the Constitution is to be a preamble or to have independent force, because their lordships have no doubt that the effect of the Prohibited Restaurant Act on Great Bay was in any event not a deprivation of property within the meaning of that section. So that is how the Privy Council treated it. And all we say is that the point was raised before the Privy Council. The Privy Council had the opportunity to disavow the ruling made by the Court of Appeal on the independent enforceability of section 1 and chose not to. So that left the Court of Appeal.
Yes, but I mean, it chose not to, or really on the basis that it was arguable either way. I mean, if you thought it was so obvious that the Court of Appeal got it right, no doubt it would have said so.
Well, that's one view. Another view is just that the court took the view that in order to arrive at the decision, it just didn't need to deal with it and left it alone. So we have the Privy Council not overturning that decision. Let's put it that way. Next, we have the case of Inchcup.
Yes.
That is at tab 12.
Yes.
What's interesting to note, my lord, is on page 4 of that case, and perhaps it may be worth finding it, at paragraph 11, there is a case that follows Olivier's case called Francis versus Chief of Police, 1973 AC, a decision of St. Kitts and Anguilla. But in any event, the relevant portion of the case for us is on page 3, paragraph 9. So there can be no question that this was an issue. The separate enforceability of Section 1 was squarely before the court, was an issue to be decided. And you can see there's a reference there to Section 1, obviously Section 1C included. And then over the page, paragraph 10, there's a reference to Olivier. And then if you look just down the page below number 40 on the left-hand side, you see the sentence beginning, Dr. Barnett focuses on the words. Though the section must be given such declaratory force as it independently possesses as supporting his submission, it is not altogether clear what is the meaning of these words, but in my judgment, in the light of the rest of the passage, it cannot mean that the whole section has independent force, regardless of the provisions of the remaining substantive sections. It seems to me that it probably means that the subsequent sections must be construed in light of this preamble. And then there's a reference to the case of Francis. And then the court says, when the Great Bay case went to the Privy Council, the board did not find it necessary to decide the question, but there is nothing in the opinion of Lord Hoffman to cast doubt on the correctness of the decision of the Court of Appeal, which is what I was trying to say to you, my lord, but this is said somewhat better. Dr. Barnett submitted that the Court of Appeal's decision was not binding on us because it was not necessary for the decision in the case, and was per incuriam because the court misunderstood the effect of Olivier's case and was in any event contrary to the prior decision of this court in Malpas. I cannot accept this submission. The ruling on Section 1 was part of the decision of the court, which gave careful consideration to the Olivier and Ferris cases. It is true that the Ferris case is an earlier decision, but though the court in that case referred to the Olivier case, they reached the conclusion which is directly in conflict with it. There is no reasoning on which it could be distinguished. In my judgment, the decision in the Ferris case must be regarded as per incuriam and wrong. And so there's a reference to other cases, but that is what this court found. And that is
that right? Isn't there authority that a decision, I'm trying to find it, it's somewhere in the papers, that a decision of the Court of Appeal is not part of the ratio if the Privy Council, on appeal from that decision, has decided that the question didn't arise for determination?
Lord, you may be looking for the case at tab 18.
That's what I am looking for, I suspect. Yes, Young and Bristol Aeroplane.
And may as well address it. And my lord, if you look at page 294.
Yes.
So the finding 3, the Court of Appeal is bound to follow previous decisions of its own, as well as those of courts of coordinate jurisdiction, 3 exceptions. may it choose between two conflicting decisions of its own, it must refuse to follow a decision of its own, which, though not expressly overruled, is inconsistent with a decision of the House of Lords. It is not bound to follow a decision of its own given per incuria. So on that basis, we say that in Inchcup, the court found itself in the position of the finding at Roman numeral 3a. It chose between two conflicting decisions of its own. Was that the...
No. I've seen it in the submissions. Keep going, but that's not the point I'm on about.
My lord,
I'll find it when we have a break.
if I can assist. I'm sorry, Mr. Duncan, I didn't mean to interrupt. I just know
Yes,
what you're looking at.
Why don't you help us, Mr. Myers?
Can you
It's
tell me what I'm
paragraph
looking
20.
for?
It's paragraph 23 of the appellant submissions, which refers to Halsbury's laws. And Halsbury's laws gives a statement of Young and Bristol Airplane, which includes the principle or the exception that your lordship is referring to.
Ah,
And that Halsbury's laws is at tab 42. And if you look there, you will see the case law that is referred to or that is relied on by Halsbury's for that exception.
go on.
It's a case called Al-Bidawi.
All right, let me just try and find first.
Sorry. Tab 42.
Mm-hmm.
Then, so there's a statement there.
Which paragraph are we looking at?
If you keep turning, we're looking at paragraph, I'm sorry, page 5.
Yes.
And I can't actually see what paragraph. Paragraph 30. It says it's headed Court of Appeal decisions. If you look at the second.
Yeah, I'm sorry, that's exactly what I'm trying to.
Yes.
Exception rule. Thus, too, it is but refused to follow a decision of its own, which will expressly overrule opinion, stand with it, and further is not bound by one of its decisions if the Supreme Court decided the case on different grounds, proving that the issue decided by the Court of Appeal did not arise for decision. That's what I am looking.
That's my lord.
So, my Lord, if I can ask respectfully, how are you construing the quartet of cases that we have with respect to this provision, just so that I have it squarely before me?
Well, where I think I've got to at the moment is this. First case, which is for us, is Rio.
Sorry, my lord, you're going in and out. I can't hear you.
Can you hear me now?
Yes, I can hear you.
Can
now.
you hear me now? Right.
Yes.
Farias is ratio. That's where we start.
Right.
Attorney General v. Great Bay is ratio for the reason that I was in the passage we've looked at. Because it went to counsel said that the relevant question didn't decision. Incup should therefore have reached the conclusion that there were not two conflicting decisions of the Court of Appeal by way of ratio, because there was only one decision of the Court of Appeal by way of ratio, namely for rights.
Sorry, my lord, are you saying that, I apologize, my lord, are you saying that Great Bay in the Court of Appeal was not ratio?
It is ratio.
It is, okay.
Well, at the time that it was decided, Great Bay in the Court of Appeal was ratio.
Yes.
However, it went to the Privy Council as a result of the Privy Council that on section 1 did not have to be did not his decision.
I'm sorry, Sir Christopher, you're breaking up. I'm finding it hard to follow.
Well, I don't know what to do about this. Can you hear me now?
Yes.
Can you, well, put your hands up if you can't hear me. I can't tell whether you can hear me or not. I'll start again. Attorney General v. Great Bay, when he decided in the Court of Appeal, became ratio. However, and therefore had to be followed by, or prima facie had to be followed by subsequent decisions of the Court of Appeal. However, when Great Bay went to the Privy Council, which decided that the issue of section 1, its independence, did not arise for decision, it ceased to be ratio because of the principle set out at 30 subsection 2 of Halsbury, that the court is not bound by one of its decisions if the Supreme Court has decided the case on different grounds, as it did in Great Bay, well, the equivalent Supreme Court, ruling that the issue decided by the Court of Appeal did not arise for decision. Do you see what I'm saying?
I'm just reading section 32. And further is not bound by one of its decisions.
That is said to rest on two cases which I haven't seen at footnote 9.
Yes, well, I'd have to look at the cases in footnote 9 to see whether, I mean, it strikes me that it would be contextual, because if the Privy Council made a decision on different grounds, but clearly didn't cast any shadow or disapproval of the decision in the Court of Appeal, one would have to consider whether or not there really was a rejection of the decision in the Court of Appeal that wasn't the subject of argument, or whether the court was basically saying, we have no concern with the portions of the decision in the Court of Appeal upon which we've had no argument today. However, we will make our decision on different grounds. It sounds as if that rule would probably apply in a way where the decision on different grounds negated the decision in the Court of Appeal.
Yeah. Well, we better have a look at these cases, which I'm not familiar with. But you were asking me what my current position is as to the Court of Appeal cases. My current position in my mind is, as I say, that Ferris was binding. Great Bay and the Court of Appeal became unbinding. Inchcup, therefore, was bound to follow Farias, but in fact it failed to do so. Inchcup was ratio. It was followed by Ferguson, that was also ratio. So there are in fact three conflicting ratio decisions of the Court of Appeal, namely Farias on the one side and Inchcup and Ferguson on the other. And if the position is that the Court of Appeal, having taken the view that there were conflicting decisions, has reached a conclusion that it will adopt one of them, which it must have done by the time of Finchcup. And if the position is that the Court of Appeal has reached a view on which to choose, it is probably the case that we cannot, second time round, decide to make a different choice, which is what I think you submit.
That is what I submit.
Yeah.
Okay.
Subject to the Privy Council.
Well, yes, and there's the Privy Council in the group of cases, Newbold and others, and then there's Jamaicans for Justice, which I'll come on to, with respect to separate enforceability of Section 1. So the last of the cases in that quartet is the case of Ferguson.
Yeah.
Well, I'm not sure whether you have Ferguson at paragraph at tab 5 or at tab 33. I'm not sure whether there are two Fergusons, and I'm not
Tab
sure.
5 is nothing to do with this issue, though, is it?
No, but yes, I said there are two Fergusons. Mine may have been switched.
Tab 33.
So it's tab 33.
Yes. Yes, I spent some time looking through Ferguson at 5 in the thought that it might be relevant, and to discover that it wasn't.
Yes.
Yes.
So you have you have the dramatis personae includes my Lord Justice Bell. You can see on page 678 that both my learned friends, Miss Sadler Best and Mr. Myers, were involved in the case. The position, unfortunately, is that what we have is paragraph 76. However, and paragraph 6 is a short riposte to the question of whether or not Section 1 is separately enforceable.
Yes.
And Mr. Duncan, what does out Bermuda mean on the first page?
That was, I think, Mr.
Gay rights thing.
Myers may be able to explain the party because he was involved in the case.
Do you
It's
see
a
what I
gay
mean?
rights pressure. I'm sorry.
Sorry, go on, Mr. Myers.
It's a gay rights pressure group
Yes.
that was one of the litigants in the case, seeking to establish that same-sex marriage was required in essence.
Oh, I see. It's nothing to do with. Yes, I see. I'm sorry, I'm missing the point. Thank you.
Yes, you're welcome, my lady.
So, my lord, what I
You
am,
say there was a lot of argument on it, which was reduced to a rather
but it, yeah,
terse conclusion, but a conclusion nonetheless.
well, yes, but importantly, and this is very important, I'm advised that the following cases were in the skeleton arguments and argued. Olivier, Great Bay, Inchcup, Newbold, Lewis, Campbell, Ferris, Nervas, Attorney General and Joseph, Societe United Docs, Thomas and Baptiste, and Attorney General and MacLeod, which is a case that I will come to.
Well, that list includes a number of cases which aren't referred to among the lists appearing at 676, which
Well,
does
yes.
not include, for instance, Ferris.
My Lord, yes, I spoke to Miss Sadler Best about that. I wasn't there, my Lord, you were there, so I will take.
I was there, but I can assure you I can't remember which cases were referred to and which were not.
I am told by Miss Sadler Best, and I stand to be corrected by Miss Sadler Best, yourself, and Mr. Myers, that those cases were the subject of argument. But again, as I said, I wasn't there, but I'm told that is the position.
The trouble is that the cases referred to may, I think, mean cases referred to in the judgment.
Yes, I think that's right.
Sometimes in English authorities, you have cases referred to in the judgment, and then another list which has the following authorities
Cited.
Yes.
cited.
Yes. No, I'm aware of that. I don't. This is the law reports of the Commonwealth, and I just don't know how that they list their cases.
Right.
But be that as it may, I think those who were present, I don't hear Mr. Myers demurring from the point, and he was on the other side to Miss Sadler Best. So they were the two parties arguing the case. The reason I say that, and that it's more important than just the paragraph there, obviously, my lord, is because the case of Lewis and Nervas were involved in the argument, and those are two cases that we're going to have to come on to in submissions.
Might be such assistance as we might perhaps have received if Ferguson had been more extensive than it was.
Well, yes. So effectively, subject to the reference from Hallsbury's that we have to address,
yes,
it is my view, as my lord has stated, that we take the view that this court is bound on the Section 1 point.
Right.
The cases that we've gone through.
Okay.
Lord, the next point that we would like to turn to is the reference to Lewis,
Yes.
Thomas, Jamaicans for Justice, and now the case of Williams, the Antiguan case, has been added to the list of cases that my friends rely on.
Right. We start with Lewis?
Well, my lord, no. What I'd like to do before we get to Lewis is I'd like to set the background to those cases. And the background is in paragraphs 46 to 60 of the skeleton argument. So the point essentially is this, in the event that the appellants suggest that Section 1A is independently enforceable. So we've got the Section 1 argument, and now we've got the Section 1A protection of the law argument. And so our submission is that if the appellants cannot establish that Section 1 is separately enforceable, it is based on the local authorities an insurmountable hurdle for them to submit that Section 1A is separately enforceable.
Yes.
And the reason for that is one has to wonder when one looks at the provisions in sections 2 to 14 of the Constitution that contain their competing and countervailing balances. How is that balance going to be struck in Section 1A? So in their skeleton argument, the appellants rely upon what was a trilogy, now it's four, a quartet of cases. And they are in order, Thomas and Baptiste, that's found at tab 32. I'm not asking the court to go to it now, I'm going to come to that shortly. The second case they rely on is Lewis, found at tab 35. The third case they rely on is Jamaicans for Justice, found at tab 16. And the fourth case that they drew the court's attention to is Williams, found at tab 29. And those cases, my lord, have been provided in chronological order, and that is important with these cases. Thomas is a 1999 case, Lewis is a 2000 case, Jamaicans for Justice is a 2019 case, and Williams is a 2020 case.
So, yes, right.
Before we get to the cases and establish whether they do assist in a separate interpretation of Section 1A, the first case I'd like to look at is not Olivier, we've looked at that already. The second case I'd like to look at is Society and United Docs, which is at tab 22. Now, in this case, this is a 1984 case, this is a judgment of Lord Templeman. In this case, the court held that with respect to the Mauritius Constitution, Section 3, the equivalent of our Section 1, is an enacting provision, giving it independent force.
Well, you say Section 3 is the equivalent of our Section 1.
Well, when I say equivalent, it's the introductory section that sets out the Section 1A equivalent.
Well, that is true,
Yes,
but its wording is markedly different.
it is. It's an enacting provision, and on page 595, we can see how it's introduced. On page 595 of the case, you see that fundamental rights and freedom of the individual are referred to, and it comprises Chapter 2 of the Mauritius Constitution, sections 3 to 19. And the introductory words are, "It is hereby recognized and declared that in Mauritius there have existed and shall continue to exist without discrimination." And then their reference to the rights and the equivalent of Section 1A, right of the individual to life, liberty, security of the person, and the protection of the law. So we can see that in this case, there is a different interpretation that is being placed on their comparator, should I say, not equivalent, of Section 1. And that's explained at page 599. Paragraph F through to the foot of the page.
Yeah.
Now, importantly, and this is where we see how Olivier tends to get legs that this court may have felt it didn't have once it was originally decided. Over the page, at page 600, we see Lord Templeman's description of Section 5 in Olivier. Paragraph D, Mr. Newman next relied on Olivier. In that case, Lord Morris, delivering the judgment of the board at page 128, describes Section 5 of the Constitution of Malta, which contains provisions similar in many respects to Section 3 of the Constitution of Mauritius, as an introduction to, and we've seen those words before, at E and F. And then he says, at F, Section 3 of the Constitution of Mauritius, on the other hand, is not a preamble in form or in substance, but is an enacting provision. In Olivier, government employees were forbidden to introduce a specified newspaper into government hospitals, and then there's more a reflection on the case rather than an interpretation of Olivier. And then I think that's all that we can get on Section 1 from the case of Societe. So they clearly draw a distinction between constitutions that have an enacting provision and constitutions such as that in Malta.
Yes.
But the court also refers to Olivier, and it begins to give it a more authoritative stamp of the Privy Council by endorsing its reasoning. The next case, Lord, is Great Bay. We've looked at Great Bay, but that's the next one in the chronological sequence. And then following Great Bay, and that's Great Bay in the Privy Council. And then following Great Bay, we have Campbell Rodriguez in 2007. That's at tab 14 of the bundle.
Yes.
Now, this is with respect to the pre-amendment Jamaican Constitution.
Yes.
Page 531. Actually, Lord, just to direct the reading further on in the case, at page 527, held number 1, Section 13 of the Constitution did not confer any separate and independent rights. On a clear interpretation of the provisions of Chapter 3 of the Constitution, the rights and freedoms enforceable under Section 25 were those set out in Sections 14 to 24 inclusive. A generous and purposive interpretation of the Constitution did not permit a distortion of the explicit relevant constitutional provisions. There's a reference to Great Bay, applied, Olivier, and Societe considered. And so now, if we go to page 531 at the top of the page, you see section 13 commencing with the words, whereas every person in Jamaica is entitled to the fundamental rights and freedoms of the individual. Then section 13A, you see the reference to protection of law.
Yes.
And then at the foot of the page, you see more explanation of what was held. It was contended on behalf of the appellants that section 13 had independent effect in the conferment of constitutional rights, which their counsel, Mr. James, describes as declaratory force. Alternatively, as a minimum, he submitted it was to be given effect as an aid to construction of section 18. The Constitutional Court and the Court of Appeal rejected the argument that section 13 had the function of an instrument for providing redress. They relied in particular on the wording in section 25(1) providing for redress in the event of contravention of any of the provisions of sections 14 to 24 of the Constitution, without reference to section 13. In Great Bay, Hoffman adverted to the familiar resemblance between constitutions of the UK overseas territories and former British possessions, now independent states. He went on, and there's a description, which I think I can pass over. And then paragraph 9, some assistance may be obtained from decisions of the board in relation to different constitutions, which Lord Hoffman discussed in some detail in Great Bay. At one end of the spectrum is that of Mauritius, considered in Societe. Section 3 of the Constitution of Mauritius contains a general statement declaring the existence of a number of rights, including that of protection from deprivation of property without compensation. Section 17 provides for application for constitutional relief where any person alleges that any of sections 3 to 16 has been contravened in relation to him. In the opinion of the board given by Lord Templeman, the wording of section 3 was only consistent with an enacting section rather than a mere preamble of introduction, and its ambit was not to be curtailed. At the other end of the spectrum is the Constitution of Dominica, which bears significant resemblance to that of Jamaica. The opening words of section 1, whereas each and all of the following are identical with those of section 13 of the Constitution. The rights and freedoms specified are phrased differently, but include protection from deprivation of property without compensation, and the final portion referring to limitations is in almost identical terms. It was considered by the board in Blomquist. Section 16 of the Constitution provided for protection from compulsory acquisition without compensation in terms which were in the material respects exactly the same as those of section 18 of the Jamaican Constitution. And then over the page, paragraph 11, in an intermediate position come the Constitutions of Malta and Bermuda. Section 5 of the Constitution of Malta, like section 1 of the Constitution of Dominica, was framed in identical terms with those of section 13 of the Constitution of Jamaica. In the opening and closing portions of the section, section 16 contained an enforcement provision similar to that contained in section 17 of the Constitution of Mauritius, applicable to all of the preceding provisions conferring rights and freedoms. Section 5 was not excluded by the wording of section 16. The case did not turn on enforceability of section 5, but Lord Morris giving the judgment of the board in Olivier, and we've read that already. And then at paragraph E, the provisions of the Constitution of Bermuda are very similar in material respects to that of Malta. They were considered by the board in Great Bay. Lord Hoffman giving the judgment of the board did not find it necessary to decide whether the general statement in section 1 was to be a preamble or to have independent force, but reviewed the cases to which their lordships have referred and drew a clear distinction between provisions such as those in section 13 and 25 of the Constitution of Jamaica and those contained in the Constitution of Mauritius. Both the Constitutional Court and the Court of Appeal rejected the appellant's argument that Section 13 conferred separate and independent rights. They regarded it as, in essence, a preamble and accepted the respondent's submission that its declaratory force was confined to declaring the rights set out in Chapter 3 of the Constitution were not being created de novo, but existed prior to the Constitution. Their lordships are satisfied that Section 13 does not confer any freestanding rights, and that on the clear interpretation of the provisions of Chapter 3, the rights and freedoms enforceable under Section 25 are to be set out in Sections 14 to 24 inclusive. So that is, I'll come back to this case on the question of deprivation of property. But for now, that is the case that endorsed the findings that were made in Olivier by incorporating them into its reasoning to draw a distinction between those constitutions that have an enacting provision where the reference to our Section 1 rights and its equivalents would be enforceable, and those constitutions that clearly don't, Bermuda falling into the hiatus position. But we then have these provisions of interpretation that aid in demonstrating that Section 1 is not enforceable. First of all, we have the reference to whereas, which has been interpreted as being of declaratory force but not enforceable. And then within Section 1, it refers to enforcement of the subsequent provisions. And that appears to be the distinction that is being drawn in Bermuda between those in Category 1 in Campbell-Rodriguez, the cases where there is enforceability and enactment, and those in Category 3, the cases where there is no enforceability because there is no reference to an enactment. Next, my Lord, we have the case of Newbold.
What tab is it, please?
Lady, I just
28.
I have it right. Tab, yes, it's at tab 28.
Thank you.
So just to remind the court, we're looking at these cases by way of background before we delve into the four cases that my learned friends rely upon in support of separate enforceability of Section 1A. Now, my Lord, on page 701 to 702 of that case, you've already gone through this. So what I'd rather do is just highlight some of the important points that spring from paragraphs 27 through to 33 of Newbold. I think you, my Lord President, took the court through these paragraphs yesterday. There are a number of important points that come out of this. First of all, it's important to remember that all three cases, Thomas, Lewis, and Joseph, were all death penalty cases. In Thomas, as the court observed yesterday, the Section 1 equivalent in Trinidad and Tobago Section 4 is an enacting provision. It has separate independent enforceability. Lewis, we say, is important because it's distinguishable on a number of grounds that I will come to when I deal with the 4 cases that the appellants rely on.
Right.
In Joseph, paragraph 31, the court divined effectively a legitimate expectation remedy. But what's important to remember about Joseph, which may not be clear and will be highlighted shortly, is this. Joseph is a case that was originally decided in the Privy Council in 2004. Lord Hoffman gave the ruling on Joseph in 2004. It's an appeal from Barbados, which in 2005 adopted the Caribbean Court of Justice as its final court of appeal. Following that, and the rejection of the appeal in the Privy Council, Joseph further appealed to the Caribbean Court of Justice and got a different result. And the confusion is highlighted in an article that I'll come to shortly. But the first...
That's a little difficult to follow. There was an appeal to the Privy Council from Barbados.
Yes,
which
2004. 2004.
Yes. Yeah, yeah. Then in 2015...
No, 2005.
The Caribbean Court of Justice was chosen as the final court of appeal.
Yes.
But were you then able to appeal things that you'd unsuccessfully appealed to the Privy Council a second time round to the Caribbean Court of Justice?
May have been on a different point, but in 2006, it went to the Caribbean Court of Justice and they rendered this decision. My Lord, if I can ask you to, I'm going to come back.
Wait. I would say they rendered the decision which we see.
Yes.
Well, you know what? If what was being dealt with in 31 is a decision of the Caribbean Court of Justice, if that had been adopted as the final court of appeal, how did it come in front of the Privy Council?
In this case, Lord Mance is referring to the judgment of Joseph. So you have a Privy Council decision in 2004.
Yes, I'm sorry. Yes. Yeah, I see. Yes, yeah.
Right. So let me help you. I'm going to come back to this, but let me help you with the confusion. Can I ask you to look at 2 things? I'm going to come back to this, and I apologize for jumping around, but I just need to show the court why the confusion exists. Can I ask you to look at tab 15, please?
15.
Yes.
Yeah.
Paragraph 4, this is the case of Nervas. You can see paragraph 4A. The issue is, one of the issues is section 11 of the Constitution separately enforceable. Paragraph 5, section 2 of the Offence of the Persons Act provides any person convicted of murder shall be sentenced and suffer death. This has been presumed as a highly complex and controversial matter, but the issue for resolution in the case may be simplified to whether it is legally permissible for the use of the word shall in section 2 of the Offences of Persons Act to be modified to may. In this context, it should be noted that this case is not about whether the death penalty is constitutional or not. It is about the circumstances under which it can be imposed. And then if I can ask you to turn over to page 7. This is the divide, sorry, to paragraph 7. This is the divide that now exists between the Caribbean Court of Justice and the Privy Council, which is why we must be careful when looking at decisions emanating from the Caribbean Court of Justice.
Sorry, what are you reading from?
Paragraph 7. So let me go to the second sentence. The court stated that, well, actually read it from the start. The ruling of the Court of Appeal applied the decision of the majority of the Privy Council in Boyce. That's where Lord Hoffman had ruled that Section 1 wasn't enforceable, or its Barbados equivalent, which will be considered in some detail later in the judgment.
What had he ruled? Lord Hoffman ruled?
What Lord Hoffman ruled was that the saving clause in the Barbados Constitution meant that the mandatory death penalty survived against a challenge that it was unconstitutional, cruel and unusual punishment, and deprived the applicant of the protection of law. There was a 5-4 majority in the Privy Council on that case of Boyce. That's what was ruled in Boyce. But that isn't the point I seek to make from the case. This is the Boyce that's referred to in Newbold. The court stated that it considered itself bound by that decision unless until it was overruled by the Caribbean Court of Justice, relying on paragraph 18 of the Caribbean Court of Justice in Attorney General and others versus Joseph and Boyce, AG Joseph and Boyce, where this court outlined its approach to judgments of the Judicial Committee of the Privy Council. The court accepted that decisions made by the Privy Council in relevant cases, while it was the final court of appeal for Barbados, were binding on Barbados unless and until they are overruled by this court. Mason J specifically applied that opinion. However, the Caribbean Court of Justice had only been established in 2005 and did not start with a body of jurisprudence. In the years that have elapsed since then, the jurisprudence of the court has been steadily developing. This requires evolution and change in relation to the approach to decisions from the Privy Council. There are cases where the jurisprudence emanating from the CCJ differs from and is inconsistent with decisions made by the Privy Council. While it was the final appellate court for Barbados, in such cases, even in the absence of a specific overruling of that decision, the Privy Council, it must be open to the courts in Barbados to apply the jurisprudence emanating from the CCJ. Now, on the Section 1 point, this is the point that's relied upon in the case of Nervous. There was an important dissenting judgment. And you can see on page 2 of the case, there's a judgment delivered by Sir Dennis Byron, and there's a judgment delivered by the Honourable Mr. Justice Anderson.
Yes.
And if I can ask you to go to paragraph 88. And this is what Mr. Justice Anderson says. And this is with respect to the Caribbean Court of Justice decision in Joseph and Boyce. The decision in Joseph and Boyce is not dispositive for 2 reasons. First, nowhere does it confront the clear mandate and implications that flow from the underlying structure of the Bill of Rights. In the face of this mandate, any conclusion based on the undesirability of limiting enforceability to a contravention of Section 18 is to reason from and is to an ought. There is no explanation of how to reconcile a separate justiciability for Section 11 with the architecture of the constitutional provisions. The explanation has work to do in drafting any external limits on the elaboration of the protection of the law clause. For taken at face value, the power of implication could cover all the substantive provisions of sections 12 to 23, thereby rendering the entire edifice of the Bill of Rights superfluous. Neither is there an indication of how internal limits on rights elaborated from Section 11 will be established ahead of litigation to ensure balance between the exercise of rights and the preservation of rights of persons impacted by that exercise. So you have the Caribbean Court of Justice saying that it will take a different course to the Privy Council. And you have the case of Joseph and Boyce with two separate decisions. And then you have a dissenting judgment explaining why there is difficulty with a separate enforceability of Section 1, because, to put it in Mr. Justice Anderson's words, there's no separate architecture within Section 1 to work out how you're going to balance those rights as you have within the enforcement provisions. The other point he makes is that effectively, if you have enforcement in the equivalent R Section 1, the subsequent provisions become superfluous. That assessment was commented on at tab 55 in an extract. In an extract from a book entitled Caribbean Constitutions, the Oxford Handbook. It's a 2019 work. It's tab 55. Well, this is relevant because it's a commentary on the relationship between the jurisprudence of the Caribbean Court of Justice and the Privy Council on Section 1 cases. As the Caribbean Court of Justice declared in Nervous, the main purpose of establishing the court was to promote the development of a Caribbean jurisprudence. What that might mean in practice has never been precisely defined, but in one of its earliest judgments, Attorney General Barbados and Boyce, the Caribbean Court of Justice explained how it would go about developing the jurisprudence. And that's the paragraph that we've already read. In Nervous, the Caribbean Court of Justice added that the development of its jurisprudence would require evolution and change in relation to the approach of decisions from the Judicial Committee of the Privy Council. The CCJ's judgment in Nervous is, however, neither respectful nor evolutionary. So Dennis Byron, for example, delivering judgment for the majority, castigates Lord Hoffman's judgment in Boyce, which I explained he had made contrary to the decision that they subsequently made, as suffering from the imperial taint of the view that what was done under the colonial regime cannot be struck down. Later in the same judgment, Sir Dennis Byron accuses Lord Hoffman in his judgment in Boyce of undermining the concepts of independence and sovereignty, and ascribes Lord Hoffman a view which the latter has never professed, namely the unacceptable idea that colonial law, as applied to colonial subjects, contained all the fundamental rights to which they were entitled. There are undoubtedly principal objections to the majority judgment in Boyce, but this is simply argument. The argument that Section 11 of the Constitution of Barbados is separately enforceable is also far from evolutionary. There is simply no precedent for this argument in the jurisprudence of the Judicial Committee of the Privy Council. Instead, the majority in Nervous, relying on an article by Robinson and Bulcan, which argues controversially that the Judicial Committee of the Privy Council has previously misconstrued such clauses. Notwithstanding the novelty of this proposition, there is no attempt to grapple with the omission of Section 11 from both Section 24 and Section 26. As Justice Anderson observed in his dissent in Nervous, there is no explanation of how to reconcile a separate justiciability of Section 11 with the architecture of the constitutional provisions. Similarly, the reliance by the CCJ in Nervous and McEwen on the modifications clause, which have been so emphatically condemned by Lord Hoffman in Boyce, demands some explanation, but none is forthcoming. Lord Hoffman's approach is simply dismissed as being based on mere conventional wisdom. The CCJ prefer instead to rely on the approach adopted by the JCPC to the modification clause in the Constitution of Bahamas in the later case of Bow and the Queen, even though the terms of appeal in that case were expressly framed so as to preclude re-argument of the points decided by the board in Boyce. Because of the decisions in Nervous and McEwen, the CCJ now finds itself directly at odds with the jurisprudence of the Privy Council. Given the size of the panel in Boyce, it is difficult to conceive of the Judicial Committee overruling that decision anytime soon. But for so long as it does not, there will be two parallel human rights systems in the region. On the one hand, the judges of those countries that subscribe to the Caribbean Court of Justice appellate jurisdiction will be to modify the entire corpus of pre-independence laws to bring those laws into conformity with the Constitution. On the other hand, the judges of countries that continue to subscribe to the Judicial Committee will remain bound to give effect to pre-independence laws, even where they violate rights and freedoms guaranteed by the Constitution. And so the last paragraph is not relevant. So I read that, Lord, to put into context how this court should look at decisions from the Caribbean Court of Justice on Section 1 of the Constitution. If we can now go back to Newbold at tab 28. Lord, we can now see in this context that Lewis was decided with respect to Section 1 without reference to prior authority, and I'll come to that in greater detail later. And then we have the case of Joseph, which is a Section 1 enforcement case, or the equivalent of Section 1, but it's out of the Caribbean Court of Justice. And the Caribbean Court of Justice has departed from the jurisprudence of the Privy Council. With that in mind, we get to paragraph 32 of Lord Mance's decision.
Have we got a copy of Attorney General v. Joseph?
I wouldn't have put it in the bundle, so I'm not sure if my learned friend has cited it. Are you talking about the Privy Council version or the one that's referred to by Lord Mance?
PCJ.
The one that's referred to by Lord Mance? The one that he says doesn't exist.
I certainly didn't put it in the bundle. I don't know whether my learned friend did.
Okay.
Mr. Myers, did you include that in the bundle?
No, because we're not relying on that case, Mr. Duncan.
So, Lord, neither party has, but I'm sure that if we need to, we can get the case for you.
Well, if nobody relies on it, probably unnecessary.
But with that background, we now go to paragraph 32.
Yes.
The case, and I think we can read it with a different context. The board does not consider that the three authorities, that's Joseph, Thomas, and Lewis, assist the appellants in the present case. They are emphatically not authority for the proposition that Article 15 of the Bahamian Constitution operates as and provides a general source of protection of human rights overlapping with the substance of all the rights provided by the subsequent specific articles. They address a completely different subject matter to the present and at best support the view that the concept of protection of law can extend to matters outside the scope of Section 18 of the Constitution. Section 18, I think, is their provision that covers fair trial rights. They address a completely different subject matter to the present. In the present case, the relevant substantive rights are to be found in Articles 21 or 23, or not at all. Article 15 in this respect no more than a preamble, as the board held in Campbell Rodriguez. There is distinction between, on the one hand, and then it goes through the constitutions of Jamaica and Bahamas and Malta. And then the distinction was recognized by the board in Societe, as well as in Campbell Rodriguez. And so,
what does Lord Mance mean by they at best support the view that the concept of protection of law can extend to matters outside the scope of Article 18? I mean, it seems to be a philosophical observation rather than
Well,
what legislation provides.
well, I don't want to make my case, my friend's case, but I suppose what the court is saying is that Section 18, which is the equivalent of our Section 6, confers protection for fair trial rights. Protection of law is seen as a procedural protection. It encompasses procedural protections, and to some extent, they cover the kinds of things that Lady Hale refers to in Jamaicans for Justice. So if you look at the cases, what they're saying is, effectively, they are due process, judicial review kind of protections where procedures have not been followed, where fair procedures have not been followed. So in Joseph, it's a legitimate expectation. In Lewis and Thomas, you'll recall in all three cases, they were death penalty cases where the national governments had entered into and signed treaties with an international body to protect those sentenced to death, giving them the right to a further appeal for clemency to that body. And in a number of instances, the national jurisdictions didn't want to wait to allow those persons to exercise that right. In one instance, they said it was taking too long to exercise the right. And so the issue arose as to whether or not they were entitled to some kind of due process, protection of law right. And what the court said is that absent another provision, they would allow that under protection of law in the event, we say, in countries like Trinidad and Tobago, where that was a separate enforceable right. We say there was no license for that in Lewis, and we'll come to explain why. And in Joseph, the Privy Council, and that's the case my Lord wants to see, but in Joseph, Lord Hoffman, referring to the savings clause, said that the death penalty was lawful and didn't give any such equivalent right. But what the Caribbean Court of Justice did in paragraph 31 is they gave that right. They said you would have that right in the equivalent of our section 1. So to answer your question, Lord, I think it's a species of protection that is analogous to procedural protections, like legitimate expectation, decisions that are irrational, unreasonable, or unfair.
Well, I half follow that. But what he appears to be saying is that the concept of the protection law can extend to matters outside the scope of Article 18. So Article 18 talks about the right to a fair trial and the like, but the concept of protection of law may extend further. It may extend to entitling you to apply to the relevant international body to consider whether you should be hanged. But if the concept of protection of law can extend to such a matter, it can only do so usefully if the section which embodies the entitlement to protection of the law has independent application. To be told that the concept of applying to the international body can go beyond the scope of Article 18, but of course you're not entitled to rely on that protection, borders on the inhumane.
Lord, this is where we have this conundrum. I'm not sure whether I assist or further confuse by showing the court what Lord Hoffman said at tab 8 in Matadine on a similar point at page 113.
Let's have a look.
Tab 8.
Tab 8, page 113 and starting at paragraph B. And it reads as follows. The construction given to the words the protection of law in section 3 must have regard to section 10, which is headed provisions to secure protection of law, and is plainly intended, as section 3 says, to give effect for the purpose of affording protection to that right. Section 10 is concerned with procedural rights, such as that of an accused person to a fair trial and a civil litigant to an impartial tribunal. Compare Article 6 of the European Convention. It contains nothing to suggest that the Constitution uses the phrase the protection of law to mean a principle of substantive equality. Their lordships do not suggest that section 10 is necessarily exhaustive of the rights conferred by those words in section 3A. That would be contrary to the construction given to section 3 by the Privy Council in Societe, where Lord Templeman, given the advice of the board, said that section 3 was not a mere preamble, but a freestanding enacting section which had to be given effect in accordance with its terms. But their lordships consider that section 10 must throw light upon the question of what kind of rights are encompassed in the concept of the protection of the law. It would be surprising if those words in section 3 had been used to mean rights of a radically different kind from those detailed in section 10.
Well, I'm not sure how that helps. Lord Hoffman there appears expressly to recognise that section 3 may give greater rights than are afforded by section 10. But you must be careful, because it would be surprising, although that is so, if the words in section 3 meant rights of a radically different kind. He's there, of course, dealing with a constitution where, as I understand it, section 3 was an enacting provision.
That's correct.
So he didn't have to deal with a situation where the concept of protection of law could give you more protection than the classic sections about fair trials and the like. But it suggested that the concept is merely a concept and doesn't actually give you any rights. Not sure that Matterdine helps on this question.
It's the other word that I thought that I would bring to the attention of the court, but where that leaves us is still that section 1 is not separately enforceable, and there is no consistent, coherent body of authority binding on this court to suggest that section 1A is separately enforceable.
Well, you may be right, but if section 1 is unenforceable, the view that the concept of protection of law can extend to matters outside the scope of Article 18 of the 1970 Constitution is true but irrelevant, because if the equivalent to section 1 has no independent force, the concept that the protection of law can extend is no more than a concept, because it doesn't.
And in addition to distinguishing the 4 cases that the appellants rely upon, we would support that view, my lord. There is no, to use Mr. Justice Anderson's phrase in Nervas, there is no architecture. It's just a concept that's thrown out there. There's no way of establishing how to enforce that right.
Right.
And what we are left with is the, if I may put it this way, more traditional position in the Privy Council authorities and indeed the Court of Appeal authorities, that we say bind this court that section 1 is not enforceable.
Well, are we going to look at Lewis at some stage?
Oh, we are. I've gone through the background, and now we're going to look at, well, the first case, and maybe I can deal with it this way. Well, the first case in the quartet is Thomas. And if I can leave it on the basis that Thomas is not really relevant because in Trinidad and Tobago, the equivalent of Section 1 is enacting provision. I can move into Lewis.
Right, okay.
So we can go to Lewis, which is at tab 35.
Yes.
Yeah.
Sorry, just give me a second.
Tab 35.
Yes.
Again, this is another death penalty case. Now, I accept that Lord Hoffman was in the minority. In fact, he gave a dissenting judgment. But paragraph 306, page 306. He says this, just so that we can put the case in context. These appeals concern the legality of the sentence of death, which in accordance with the law of Jamaica has been passed upon 6 prisoners convicted of murder. The questions raised are of the utmost importance, not only for the prisoners whose lives are at stake, but also for the administration of justice in Jamaica and the other Commonwealth countries of the Caribbean. The board sits as a Supreme Court of Appeal to enforce their laws and constitution. It is, of course, obvious to the members of the board they must discharge that duty without regard to whether they personally favor death penalty or not, but the wider public may need to be reminded. There are 3 questions which arise. The first, the Jamaican Privy Council issue, is whether the Jamaican Privy Council, before deciding whether or not to recommend to the governor that a sentence of death be commuted, is required to disclose to the prisoner the information which it has received pursuant to Section 91 of the Constitution. That was the question in the case.
Right.
The second, the Inter-American Commission issue, is whether it would be unlawful to execute a sentence of death while the prisoner's petition remained under consideration by the Inter-American Commission on Human Rights. The third, the prison conditions issue, is we don't need to deal with that issue. Right. So we now can go back to page 303 with those issues in mind to see how Lord Slynn decided the case. And at the foot of page 302, Lord Slynn says, it is of course well established that a ratified but unincorporated treaty, although it creates obligations of the state under international law, does not in the ordinary way create rights for individuals enforceable in domestic courts. This was the principle applied in Fisher number 2. But even assuming that that applies to international treaties dealing with human rights, that is not the end of the matter. Their lordships agree with the Court of Appeal in Lewis that the protection of the law covers the same ground as the entitlement to due process. Such protection is recognized in Jamaica by Section 13 of the Constitution and has to be found in the common law. Their lordships do not consider that it is right to distinguish between a constitution which does not have a reference to due process of law, but does have a reference to the protection of law. They therefore consider that what was said in Thomas versus Baptiste, to which they have referred, is to be applied mutandis to the constitution like the one in Jamaica, which provides for the protection of law. So, and then it goes on to say, in their lordships' view, when Jamaica acceded to the convention and to the international covenant and allowed individual petitions, the petitioner became entitled under the protection of law provision in Section 13 to complete the human rights petition procedure and to obtain the reports of the human rights bodies for the Jamaican Privy Council to consider before it dealt with the application for mercy and to staying of the execution until those reports had been received and considered. So that was the issue that the court was dealing with. We seek to distinguish this case on these grounds. First, the issue of separate enforceability of Section 13, our equivalent of Section 1, does not appear to have been an issue that was argued before the court from the judgment. Lord Hoffman identifies 3 issues. There is no reference to any of the binding authorities, which at that time would have been, I remember, my lord, this case is in 2000. So at that time, it would have only been Olivier and Société United Docs. I don't know whether it would have included Great Bay, because Great Bay was decided the same year as this case.
Well, Great Bay was actually decided in 1999, I think. The report is in 2000.
Right. Well, then that adds to my argument that Great Bay was not mentioned. So there was no argument on the separate enforceability of Section 1, and none of the cases that are either binding or relevant to a determination.
Well, wait a minute. Olivier wasn't binding.
Société refers to the reasoning in Olivier and adopts it, and Great Bay
Says it wasn't going to make a decision.
Sorry, my lord?
Said the Privy Council said it wasn't necessary to make a decision.
Lord, yes, but regardless of not referring to those cases, there is no argument in this case about Section 1. All we have are 2 paragraphs on page 303. No reasoning, no rationale, and to go back to the words of Mr. Justice Anderson in Nervas, no explanation of how this section is going to work within the, to use his words, architecture of the Constitution. And that is why, Lord, you'll recall in paragraph 29 of Newbold, I'm not asking the court to go back there, you see Lord Mance refers to Lewis, and one view of his words are that he's trying to work out how the decision in Lewis was arrived at.
Well,
He says, nonetheless, the decision was arrived at. So top of, actually it's 29. He says, well, foot of page 701, Lewis, the circumstances were similar. The appellant contended that they should not be executed, blah, 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 blah. Then he says, nonetheless, the board, without commenting on this difference, treated the protection of law to which Article 13 of the Jamaican Constitution, Article 15 of the Bahamian Constitution refers, as equivalent to due process law referred to in the Constitution of Trinidad and Tobago, Lord Hoffman dissenting. It thus applied the reasoning in Thomas to reach a conclusion that execution could be stayed. The nonetheless is the lack of comparability between the due process clause in Thomas in Trinidad and Tobago and the protection of law clause in the Jamaican Constitution. He was trying to work out how you could use a provision from a constitution that is different and in relation to a constitution where there is direct enforcement in a constitution in Jamaica where you don't have direct enforcement of Section 1 based upon the the authorities up to that time, 2000.
Well, I follow the difficulty. Nonetheless, Lewis was authority of the Privy Council for the proposition set out at page 277 of the headnote, that the appellants on petitioning the Privy Council of Jamaica for mercy were entitled to the protection of the law in accordance with section 13 of the Constitution. So Lord Mance had before him a decision whose ratio was that which I have just described. And in those, I can see that one can say, well, we don't have to follow it because the contrary wasn't argued. But what he in fact says is they address a completely different subject matter and at best support the view that the concept of protection of the law can extend to matters outside the scope of Article 18. Well, that's simply a complete underestimation of what, whether rightly or wrongly, Lewis decides, which is that even in a constitution where the due process clause, where the enforcement clause doesn't apply to the equivalent of section 1, the appellant in question was entitled to the protection of the law in accordance with section 1. Decide that as providing at best support for the view that the concept of the protection of law can extend to matters outside the scope of Article 18 is a gross reduction of the significance of the decision in Lewis, isn't it?
Well, I would only say this, that would only be on the assumption, Lord, that the issues were properly argued before the court in Lewis, which would then lead Lord Mance in Newbold, where they clearly were properly argued in some depth, to have concern about how that decision was arrived at, when it seems as if it's based upon a jurisdiction where that decision can't be supported, Trinidad and Tobago. It relied on Thomas. There are two distinguishing factors with Thomas that he clearly identifies. One, that there is a separate enacting right in Trinidad and Tobago for the equivalent of section 1.
Well, I follow that. It's the way he deals with Lewis that's borders on the curious.
Yes, it is Lewis.
What? No, it's his treatment of what he says about Lewis that seems very odd. I mean, I can just about see that you could say, although Lewis decided that there was an independent right, the contrary wasn't argued, and in those circumstances we don't intend to follow it, and it should therefore be regarded as indicating no more that there can be a difference between protection of law and the specific provisions of the other paragraphs of the Constitution. Though that latter, adding that on would be quite unnecessary. But he doesn't seem to address the question at all as to whether or not they're bound to follow a decision of the same body, which is the opposite of the decision that he reached.
Well, my Lord, this is where it becomes problematic, because there are a number of other cases that say that section 1 is not enforceable.
But what are we to do? We've gone through the position in relation to the effect of previous decisions of the Court of Appeal. We've now moved up a grade to the Privy Council. What are we to do if there's an early decision of the Privy Council to the effect that even if the enforcement provision doesn't extend to the initial section, there's an entitlement under the initial section. So there's that decision of the Privy Council, followed by Newbold, which decides that there wasn't an entitlement under the equivalent under section 1, but Newbold was decided in a context where the enforcement provision didn't extend to section 1 because it specifically extended to a number of specified sections, whereas in the present case, the enforcement provision extends to all it tends to all previous, well, extends to previous provisions of the Constitution, so that there's a distinction between this case and Newbold on its facts.
And my lord,
Where are we?
well, we have Campbell Rodriguez, which is the 2007 case that clearly says that Section 1 is not enforceable.
Yes.
That is the Jamaican Constitution, 2007, which is the same vintage of constitution as the Constitution in Lewis. Campbell Rodriguez, 2007, makes it quite plain that Section 1 or its equivalent, and by equivalent, what I mean is a constitution where it doesn't have enacting force.
Yes.
The Constitution is not enforceable.
Yes. Needless to say, Lewis wasn't cited. Doesn't appear to have been cited in Campbell Rodriguez.
Let me just check.
Seems to be a rule
It's not referred to, Mr. Duncan.
not referred to.
Right. So, my lord, Campbell Rodriguez comes after Lewis. We would say that, yeah, Campbell Rodriguez.
Right. So we've got Lewis, which decides that it is enforceable. We've got Campbell Rodriguez that says that it wasn't enforceable, but in which Lewis is not cited. We then have Newbold, which doesn't purport to choose between, well, difficult to say that it purported to choose between Lewis and Campbell Rodriguez, when it said that Lewis wasn't of any assistance.
Lord, I would submit that based upon the way that the matter was argued in Lewis, the more reliable case is Campbell Rodriguez, where this matter was ventilated, and Bermuda and its constitution was specifically referred to.
Yes. Right. Okay.
Lord, after Lewis, we come to Jamaicans for Justice.
Yes.
And my Lord, with the Jamaicans for Justice, I'd like to direct the court to the skeleton argument that was provided today.
Yeah. Just before we get to that, of course, by the time we get to Jamaicans for Justice, the Jamaican Constitution had been dramatically altered.
Yes, which is one of the reasons why we say it's distinguishable in this case, because one has to look at where the whereas provision is and where the protection of law provision is. We say the protection of law provision in Jamaicans for Justice was separately enforceable because it's in an enacting provision. And that's why the case is of little value in this case. And so if I can...
Well, I think you may be right on that, but that leaves us with the problem that we've got Lewis, Campbell, Rodriguez, and Newbold to grapple with.
Yes, my Lord, I'm not sure whether other your fellow judges have formed the view you have, but
No, I think you should develop your submissions.
Right. So, my Lord, Jamaicans for Justice is at tab 16.
Mm-hmm.
We say that it's also referred to in our skeleton argument, the first one, but I'd like to start with the skeleton argument that was filed today.
Yes.
paragraph 4, you'll see that the Jamaican Constitution was amended in 2011. Paragraph 4 of the skeleton argument refers to paragraph 21 of the judgment. You can see that the Jamaican Constitution was amended in 2011. And then returning to the skeleton argument, paragraph 4, prior to the amendment, section 13 of the Jamaican Constitution read similarly to the Bermuda Constitution, with the entirety of section 13 commencing with the word whereas. The placing of the word whereas in the amended Jamaican Constitution, which is interpreted by Lady Hale in Jamaicans for Justice, only qualifies section 13(1). And if you look at page 125 of the judgment, you'll see section 13 and then 1, whereas, but it's not outside of section 1. And then paragraph 5 of our skeleton argument. Secondly, section 13(1) is not expressly relied on in Jamaicans for Justice. Lady Justice Hale makes the point in paragraph 23 of the judgment, where she says, it is clear to this board that the Public Service Commission, like the JCF and INDICOM and other organs of the state, must exercise its functions in a manner which is compatible with the fundamental rights of all persons, including, and then it's the right to life, the right to equality before the law, the right to due process of the law, guaranteed by sections 13(2), 3A, G, and R. Section 13(2), still on page 125 of the judgment, looking at paragraph 6 of the skeleton, section 13(2) does not commence with the word whereas, and expressly gives effect to fundamental rights and freedoms contained in subsections 3 and 6 and sections 14 to 17 of the Jamaican Constitution, in a similar manner to section 2 to 14 of the Bermuda Constitution.
Why do we have, Mr. Duncan, if you look at page 125 of Jamaicans for Justice, in paragraph 2, you've got ... which suggests that some words have been omitted.
I suppose these were the material words for the judgment. We'd have to get the Constitution itself to find those words.
Yeah.
But the use of the words, this chapter guarantees the rights and freedoms, set out in subsection 3 and 6 of this section, and sections 14, 15, 16, and 17 are enacting words. Section 13(3) of the Jamaican Constitution therefore has the status equivalent to sections 2 to 14 of the Bermuda Constitution, because subsection 2 is referring specifically to subsection 3 and 6. So section 13(3) refers to the right to equality before the law.
Yes.
Paragraph 7 of the skeleton argument, as section 13(3) is independently enforceable and section 13(1) was not being relied upon, the reference to nervous is of no assistance to the appellant in relation to the independent enforceability of the protection of law provision in section 1A. Thirdly, the Jamaican Constitution does not contain any provision for protection of the law, which is why Lady Hale relied on the common law principles, and that's set out in paragraph 24 of the judgment. The board is also disposed to accept that the right to equality before the law, like the right to the equal protection of the law, affords every person protection against irrationality, unreasonableness, fundamental unfairness, or the arbitrary exercise of power. These are in any event fundamental common law principles governing the exercise of public functions. As there is nothing in the statutory framework governing the PSC to contradict them, they are applicable in this case, irrespective of whether or not they have the status of a constitutional right. Paragraph 9, Lady Hale only relies on nervous to assist with defining the scope of equality before the law in section 13.3G on the previous page, which was what she had to rely on in this case to ensure that there was a proper investigation before the appointment of the police officer in question. And my lord, that is paragraph 9 of the skeleton argument, that reference to the kind of public law test for judicial review is what I was referring to as part of the way the courts have loosely tried to define the expansion of protection of law beyond the fair trial rights. Continuing in paragraph 9 of the skeleton, further, nervous is used to define the scope of the rights at common law, and these are the important words, my lord, whether or not they have the status of a constitutional right. So she's not positively asserting that they do have the status of a constitutional right. What the Privy Council was doing was only defining the scope of equality before the law under the Jamaican Constitution and at common law, nothing to do with the equivalent of our Section 1A protection of law. Fourthly, for the reasons given, the above question of independent enforcement of Section 13.2 and 3 of the Jamaican Constitution was clearly not before the Privy Council in Jamaicans for Justice. That would explain why critical cases such as Olivier, Newbold, and Campbell Rodriguez were not cited. It's a similar malady that afflicts Lewis. However, Lewis does have a finding, as the Lord has indicated, that is suggestive of something more. As such, there is nothing in Jamaicans for Justice that can assist the appellant with the independent enforceability of the protection of law provision in Section 1A of the Constitution.
Yes. Right.
And then, Lord, next, just continuing with the skeleton argument, because the next proposition the appellants rely upon is that protection of the law is inherently under the rule of law. All right. Lord, I'm going to postpone that argument to the rule of law argument and section 7AA of the Municipalities Act. So those are our submissions on the applicability of Thomas, Lewis, and Jamaicans for Justice. The last of the cases they referred to was the case of Williams.
Mm-hmm.
Williams is at, I think it's tab 29. 29. Oh, it was 33. I have it written down wrong.
29.
It's 29, yes.
Yes.
I didn't manage to print out a full copy of the Antigua and Barbuda Constitution, but you have it. And the simple point here is that
So when you say you have it, where have we?
it should have been in the email that was sent to you this morning. That
I see.
two cases and the Antigua Barbuda Constitution. So
Right.
So the position is that in this case, the appellants rely upon the separate enforceability of Section 3 of the Antigua and Barbuda Constitution. Section 3 is found on page 240 of the case. Top of page 240, you'll see Section 3. Whereas every person in Antigua and Barbuda is entitled to the fundamental rights and freedoms of the individual, that is to say, and you'll see a protection of the law.
Yes.
Lord, Section 18 of the Antigua and Barbuda Constitution, which you have, I will have mine immediately after the break. It just didn't get printed out. You will have Section 18. Section 18 establishes that this provision is independently enforceable.
I'm sure it does, but let me just find it.
Right, yes, Section 1, I've just been shown it. Section 18.1, if any person alleges any of the provisions of sections 3 to 17 inclusive of this constitution has been, is being, or is likely to be contravened in relation to him, or in the case of a person who is detained, if any other person alleges such a contravention in relation to the detained person, then without prejudice to any other action with respect to the same that is lawfully available, that person may apply to the High Court for redress. So that includes Section 3. So it's separately enforceable. So that case is of no application. We say, so.
Right.
Yeah, and I'm being reminded that it doesn't use the word subsequent provisions, which is used, the Section 18 doesn't use the word subsequent provisions, which is used in our Section 1. Yeah. Yes.
Yeah.
So, Lord, just to recap where we started, where we started is that the appellants rely on a quartet of cases to say that Section 1A is enforceable. Thomas, Lewis, Jamaicans for Justice, and Williams. We have distinguished Thomas. It's not separate. There's a separate enforceability provision in Section 4 of the Trinidad and Tobago Constitution. We say Lewis didn't fully argue the Section 1 point, and the cases that one would have thought would have been addressed before the court were not argued. Indeed, my Lord, Lord Hoffman set out what the three issues were, and it just seems as if Lord Slynn made that point. The reality is that in Jamaicans for Justice, there is no protection of law provision equivalent to Bermuda, and the equality before the law provision that Lady Hale was dealing with was contained in a section that had separate enforceability. And in any event, and my Lord, I should have, just reminds me, I do apologize. There's one small point in Jamaicans for Justice that really does demonstrate. It's at paragraph 28, and I can read it. In the board's view, the common law provides a straightforward answer to the question. Before the Court of Appeal, the case got bogged down. So in essence, it seems as if Jamaicans for Justice decided the case on the common law.
Yes.
Not on section 13.3G with respect to equality before the law. So we say Jamaicans for Justice is distinguishable for the reasons we've said. And as far as Williams is concerned, again, section 3, interpreted through section 18 of the Antigua and Barbuda Constitution, is independently enforceable. And so for those reasons, we say that the cases relied upon by the appellants to support separate enforceability of Section 1A are all distinguishable on important material grounds, and the court should defer to Section 1 not having separate enforceability based upon Newbold, Campbell Rodriguez, and the Bermuda cases. My Lord, I should say, and maybe there may have to be some minor investigation of this. My understanding is, despite the fact that Lewis is not in the cases listed in Ferguson, it was argued in Ferguson. And the court still rejected the proposition that Section 1 had any independent enforceability. And I do think that that is important. And I note the very short paragraph 76 that Sir Scott Baker relied upon to dismiss the argument. But you know, we've got a number of parties here that were present in the case, and at least one of them, Ms. Sadler Best, is reasonably firm in her view that Lewis was one of the cases that was argued before the court. So, my Lord, I see the time is 11:59.
Yes, I think we must let Mr. Myers go and get his jab.
Yes.
Indeed, my lord.
Shall we adjourn for 45 minutes or so near there too, as we can safely get, subject to Mr. Myers' injection?
Yes.
Very good.
Thank you, my lord. I'm going to run.
Take care.
Thank you, my lord.
What's happening now?
Do we go to the breakout room?
So Christopher, are you going to the breakout room?
Yeah, oh, sorry, yes.
So the page number is 536.
536, paragraph 11.
Paragraph 11. Not five.
And we need to go through purpose.
That we're on.
Carry on.
Now, I know we haven't got Mr. Miles with us, but we've got Sir Geoffrey, and I think in the interest of time, we should proceed.
Yes, my lord. We'll fill Mr. Miles in as best we can.
Thank you. Right, Mr. Duncan.
Thank you, my lord. Can I just ask one preliminary question with respect to time? Is the court thinking of sitting late today, or is it a hard stop at 3:30 to get this?
Well, it's not thinking of sitting late today. I mean, we would normally stop at 3:30. I mean, if the position is that we were very close to finishing, then we might continue for a bit, though a number of us have been proceeding upon the basis that we will stop at 3:30.
Right. Okay.
So I should think no, unless only a short extension can guarantee the conclusion of the proceedings.
Thank you, my lord. Can I start by taking you to paragraph 30 of the skeleton argument dated the 17th of September?
Sorry, whose skeleton argument is that? Yours or
The
yours?
first one dated the 17th of
Yes.
September.
Yes.
So, Lord, I'm going back to a point with respect to how this court should treat the position it finds itself in with respect to ferries on the one hand, Great Bay, Inchcup, and Ferguson
Yes.
on the other hand. And one of the principles we pray in aid is that one of the tasks of the court in the face of those decisions is to try and bring clarity to the decision-making process in the future by selecting on proper principles which of the cases it is going to follow when there has been conflicting Court of Appeal decisions.
Yes.
And what the case of Bain says.
Just a minute, Mr. Duncan. I mean, Stuart Smith JA didn't say in terms that that was the exercise that he was doing, did he? He simply said that Ferris was wrongly decided and per incuriam.
Lord, that's correct. There are a couple of ways to look at this. One is to look at what Mr. Justice Stuart Smith did in Ferris, and then look in Inchcup, and then subsequently look at what happened in Ferguson. So you look at those cases together. You look at Ferris on the one hand, you look at Great Bay, you look at Inchcup, and you look at Ferguson. That's one way of looking at it, and that's partly what I'm addressing. But the other way of looking at it is, what does this court do now in the face of those decisions? So
yes.
the first question is, when the Court of Appeal in Inchcup was faced with Ferris and Great Bay, it was entitled at that point to say that one of its functions was, in addition to dealing with whether or not the matter was per incuriam, there was a requirement of that court to try and ensure that it made the law clear and understandable with respect to the Section 1 point. It may not have been explicitly stated, but that was one of the things it was explicitly trying to do. That is the function of a court in the position where it faces conflicting decisions. Applying Young and Bristol and the aeroplane to try and bring some clarity to what the position is. And if you look at paragraph 30 of the skeleton argument, or you look at, you have it open, paragraph 94 of the judgment, this is what the court says it is charged to do. Having established that the De Silva decision is inconsistent with several decisions of this Court of Appeal and of the Privy Council, the question arises, how is this conflict to be resolved? In this appeal, this court sits as an intermediate court. It is settled law that as a general rule, an appellate court ought to follow its own decisions. However, in circumstances where there are two or more inconsistent decisions, the appeal court must decide which one is correct and should be followed. It is settled that as a matter of judicial policy, the Court of Appeal should aim to achieve certainty in the law and should abhor confusion. Equally, it has long been widely accepted that one of the chief functions of the appellate court is to correct wrong decisions, to ensure that no judicial precedent that has been wrongly decided be allowed to go uncorrected. Young and Bristol Aeroplane has long laid down the three well-known exceptions to the circumstances in which the Court of Appeal can refuse to follow its own decisions. Based on the analysis and conclusions in relation to the first issue, it is immediately apparent that, in our view, a long line of authority which is inconsistent with De Silva, this court has to determine whether to overrule the decision in De Silva and determine which of the two sets of conflicting authorities represents the law under the well-known exception in Young and Bristol Aeroplane. In Young versus Bristol Aeroplane, it was held, and then it goes through the 3 points. Then 96, applying the first and second exceptions in Young and Bristol Aeroplane, I find that the decision in De Silva is inconsistent with several decisions of our Court of Appeal and the Privy Council. It does not reflect the law, is plainly wrong, and therefore cannot stand. So in this case, we say that when the Court of Appeal in Inchcup was faced with the decisions in Great Bay and Ferris, it had to make a decision at that point. And the decision it made was that Ferris had incorrectly applied the law in Olivier.
Now, just pause there. Looking at the position at the time of Inchcup, it had a decision in Ferris, which was ratio, was it not?
Yes.
It may have been, quote, wrong, close quotes,
Yes.
in that its analysis of Olivier may have been defective, and Olivier was in any event obiter, but Ferris was Ferris, and it was ratio. Next, you had Great Bay, which, if the line of authority referred to in Halsbury, which we were looking at before the break, is accurate, had the decision in Great Bay had ceased to be ratio binding on the Court of Appeal subsequently because of the way the matter had been treated in the Privy Council. If that analysis be right, at the time of Inchcup, it wasn't faced with two decisions of the Court of Appeal which were ratio. If the position is that the Court of Appeal sits at a time when there are two decisions, the ratios of the rationes of which are inconsistent, it must necessarily decide which one to adopt. But if it is faced with the position where there is one case before it, I mean temporarily before it, which is ratio, and one which is obiter, surely it is bound to follow the case which is ratio.
My Lord, we haven't had a chance to look at the Privy Council authority. I think it's a House of Lords authority that you're referring to, that Mr. Myers drew to the attention of the court.
Yes.
But, Lord, from this stance, we have some difficulty with the application of that in the Great Bay case, and we'd need to know what the parameters of that principle are.
Yeah.
If we take, for example, the Great Bay case, there are essentially 2 points in that case at the appellate level. There was the enforcement of property rights under Section 13 and the enforcement of property rights under Section 1C. The appellants lost on both grounds before the Court of Appeal and appealed on both grounds before the Court of Appeal. The Court of Appeal decided that they lost on the Section 13 point, and there was no need to address the Section 1C point. I've already made the point that, in our view, that didn't impact on the Section 1C argument as it was decided in the Court of Appeal. But more importantly, the issue is, I think, this. If the appellants could have got home on either Section 1C or Section 13, the fact that the court, the board in the Privy Council said, we only need to decide whether or not they got home under Section 13, doesn't mean that the finding, logically doesn't mean that the finding of the Court of Appeal in respect of Section 1C goes, because the appellants would have always then had a right to proceed or say that they still had an argument under Section 1C. That Section 1C must still be in place as a finding of the Court of Appeal in combination with the finding that the Privy Council made in relation to Section 13.
Well, that depends on the ambit of the proposition set out in Halsbury, for which we've got the Halsbury section, but we haven't seen the relevant authorities.
Right. Well, I mean,
you'll have to come back, parties may well have to give us a note on this. And my question was on the premise that what is said in Halsbury was correct. If it's not correct, the argument falls away. But if it's correct,
yes,
it would seem to me that at the time of Inchcup, it may not matter in view what happened thereafter, but that at the time of Inchcup, there was only one decision by way of ratio of the Court of Appeal which preceded it.
And my Lord, you've heard my argument, and obviously we have to see what the House of Lords has said in that reference. But moving to the position now,
Oh, yes.
we've had Ferguson.
Quite.
We've had Ferguson since that time.
Yes.
And so this court is faced with, how can I put it? I mean, it's difficult for this court to say Ferguson, Inchcup, and Great Bay were all wrongly decided. The reality is that this court now has got to look at least Ferguson as...
Well, the position we've reached now is that there are 3 decisions of the Court of Appeal, all of them ratio. The first is Fergus, which said that there was an independent right. The second is Inchcup, and the third is Ferguson, which say that there is no independent right.
Well, and Great Bay.
Well, I'm leaving out Great Bay for the moment because it gives rise to the complication that if Great Bay is obiter, we can forget about it or has become obiter.
Right.
But park that for the moment because it's rather too recondite and rococo a question. But leaving aside Great Bay, your point, I would have thought, is that the Ferrius was ratio, Inchcote was ratio, and Ferguson is ratio. And we are therefore in the position that there have been two decisions by way of ratio of the Court of Appeal, which have decided to prefer themselves over Ferrius. And that's it.
Well, then that's our submission.
Well, certainly Ferguson, certainly by the time of Ferguson, there was an inconsistency between Ferrius and Inchcote. Ferguson decided to follow Inchcote. And you say if the Court of Appeal has made a decision that it will choose one out of two inconsistent decisions, it can't be right for a subsequent Court of Appeal to decide it should make a different choice. Otherwise, the thing goes round in circles.
Yes.
Yeah, I follow that.
Thank you, my lord. I'll leave that point. I just wanted to bring your attention to the case of Bain, and you have that at tab 20, paragraph.
Yes.
4. So I can move on now. Before I turn to my deprivation of property argument, I'd like to make reference to one case that has been referred to by my learned friends, which is currently before the Privy Council.
Yes.
That is the case of Chandler.
Yeah, the case that was heard by the Privy Council last week.
Yes.
Mm-hmm.
Lord, we actually downloaded the skeleton arguments for that case, and we spent a little bit of time, you may ask, have we got nothing better to do, listening to the feed of the arguments that were made in the case.
Yes.
My learned friend, Mr. Hawthorne, who's with me, is laughing because he did the listening.
Yes.
But in any event, the issue is this. My learned friends have said that Nervase is before the Privy Council, and the issue of Section 1's independent enforceability is again before the Privy Council. And we would again like to put that case in context, the Nervase case and the case of Chandler in context as from what we heard. First of all, the matter is being heard by a 9-panel board of the Privy Council. Secondly, it is a death penalty case. Thirdly, neither party has addressed the court on the enforceability of Section 1 in the sense that's being advanced in this case. And the reason would be apparent based on our earlier submissions, and that is because the Constitution in Trinidad and Tobago has an equivalent of Section 1 that's separately enforceable, Section 4.
Yes.
Section 4 is an enacting provision, so there is no need for the court to construe the equivalent of our Section 1 as producing rights or that it is a preamble to the Constitution.
Yes.
And so, and the issue in that case concerns whether the court is going to overturn a previous case called Matthews and adopt the Nervase principle in so doing, namely equality before the law. But as far as separate enforceability of the equivalent of our Section 1 is concerned, we say that it has little, if any, relevance. So those are the points we make on the Chandler case.
My lord, my lady, I have returned. Just to here I am.
Oh, good, good. I hope you're fine.
So far, so good, my lord. Thank you.
Right.
If I can now turn to the deprivation of property point.
Yes.
Well, that's found in paragraphs 61 to 83 of the skeleton argument dated the 17th of September. 61 to 83.
Yes.
Now, Lord, we say, and indeed,
Sorry, could you just tell me this is your earlier skeleton argument?
yes,
Yeah, I'll just get it. I'll just get it.
And I
Anyway,
was doing something else,
understand.
Mr. Duncan. The paragraph numbers in your skeleton are.
61 to 83.
Thank you.
Just before you get to that, one final point on the section 1 independent validity enacting effect question. The rights that are referred to in section 1 are capable of extending beyond what the following sections provide. For instance, the protection of the law dealt with in section 6 deals only with legal proceedings, both criminal and civil, whereas the protection of the law could be said to go further than that by providing a right to protection against irrational decisions or the like. The protection of privacy is dealt with in section 1 and section 7, which deals with searches, but one might invoke the protection for privacy if one complained that the state was listening into your telephone conversations. And the provision about deprivation of property is capable of going wider than taking possession or compulsory acquisition of property. What is said is that in circumstances where section 1 refers to the existence of rights which go beyond what is contained in the subsequent sections, it would be rather odd if in fact those rights weren't rights at all.
Lord, my understanding of how section 1 is used is that if section 1 is not independently enforceable, it can be used to interpret the substantive sections 2 to 14, which is what the cases of Olivier and I think Campbell Rodriguez say. But if what my Lord is saying is that for each and every one of those sections, A1A through to C, that have reflection in a fundamental right in sections 2 to 14, they can expand the substantive rights in those sections, then we would submit that is not the case. I think the principle that Lord Hoffman enunciated in Matadine, which, Lord, you said you didn't find too helpful, but the core of it is that you can use the enacting sections have their own force, but you can use the section 1 equivalents for the purpose of interpreting the substantive sections, but you don't use those sections to confer separate and independent rights.
Well, that gives rise to an interesting question. Perhaps this dispute is all completely arid. Section 13 deals with the compulsory acquisition of a right or interest in property. Can one say, using section 1 as a guide to the interpretation of section 13, that the compulsory acquisition of a right or interest in property must extend to what amounts to the compulsory deprivation of a property?
We say no, and we say that when you look at the authorities that we're about to come to, they show you there are 5 authorities. My learned friend has gone through, I think, 2 or 3 of them, but we say those cases show you how to interpret the equivalent of a section 13 right, and it's not in that way. It's with respect to a taking, and I'll go through the cases, whether there's been a taking, a clear acquisition, control, the degree of control. Yeah. There are some propositions set out in those cases that help interpret how you consider whether or not there's been a contravention of our section 13 or the equivalent.
So the reference to deprivation in section 1 is of no assistance whatever to the interpretation of section 13.
In our constitution, I would say no.
So the proposition that section 1 may be used to interpret sections 2 to 14 is barren of content insofar as the reference to deprivation in section 1 is concerned.
Well, the cases say you can use the phrase deprivation to, as I say, interpret the section 13 rights. But what they say is you can't use deprivation as a separate, you can't use the phrase deprivation of property as a separate enforceable right.
Well, how is the use of deprivation an aid to the interpretation of compulsory acquisition?
Well, let's see what the cases say, my lord. I will take you to them and show you how it is used.
How what is used?
The phrase in consistent constitutions in their enacting provision that relates to deprivation of property, how that is used to interpret the substantive right within the Constitution.
Yeah, that would be helpful.
Right. So there are 5 cases that in some parts you've been referred to. There is the case of Lawrence. It's a 1985 case at tab 47. I'm not asking you to go to that right now. I'm going to give you the list. I'm going to give you the propositions, and then I'll go to the cases.
Okay.
There is the case of La Campagne. It's a 1995 case at tab 14. There's the case of Panton, which is a 2001 case at tab 48. There's Campbell and Rodriguez, which is a 2008 case, and it slips me, I've referred to it already today, but I'm not sure what tab number it's at.
14.
14.
14.
Which means that Campania can't also be at tab 14.
Right.
La Compagnie Sucrière is at tab 28. 23, I'm sorry, 23.
23.
What about Papanet?
Papanet's, that's the last case I was going to refer to.
Right, okay, sorry. I thought you finished.
That's at 49. Tab 49.
Yeah.
So we say the following propositions can be gleaned from those cases. First, that section 1C or its constitutional equivalents in the various jurisdictions is not independently enforceable. Secondly, that section 1C is to be read together with section 13.
Right.
Thirdly, there must be evidence of a taking or acquisition of property to amount to a deprivation of property. For the mere loss of control of property is insufficient to amount to a taking of property. Five, of itself, the restricted use of property does not amount to a taking of property. Six, the loss of control of property doesn't mean you no longer own the property. Seven, the courts have drawn a distinction between regulatory statutes and confiscatory statutes, the former not being interpreted as taking of property. 8, for control to amount to taking property, the interference must be substantial. And to amount to 9, to amount to taking under the Constitution, there must be evidence of a change in the value of the aggrieved party's identifiable property. Ten, even an adverse economic impact by statutory measures upon the aggrieved party does not necessarily amount to a taking of property. And 11, the assumption of management over property does not involve a taking away of that property. So now I'll start with the authorities.
Could you just explain to me, I'm looking at paragraph 68 of your skeleton. Why does the fact that the appellant is a public body created and limited entirely by statute means that you're not depriving the corporation of property? I mean, are you going back to the section, to section 13? Or what other reason are you putting for that?
Well, the fact that all the property that the corporation has, it derives, it's derived from the public.
Yeah, okay, but it's not government property, is it?
No, it's public property, that's correct.
Yeah, okay, but I mean, it's municipal property. So why does that make a distinction?
Well, because at the end of the day, the corporation is administering funds that it receives through the public, from the public.
Yes, but from a limited class of the public and not
When you say
through...
limited class, my lady, I mean, it's the whole public. I mean, the public pay wharf fees, the public paid parking fees. It's not a limited class.
I'm a little lost. If the government says we'll have the town hall, that's plainly a taking of property, and the fact that the town hall is owned by a municipal body doesn't alter that, does it?
Well, it does in the sense that we say that the property, we reiterate the property is public. It's the source of the money that they have is through the public.
So what? The mayor and corporation are a separate entity. They are a form of corporation. They are specifically entitled to own property. If you take the property away from them, the fact that they are a municipal corporation doesn't alter the fact that you've taken their property.
Well, I mean, I'll come back to that, but I think that we still make our argument. I mean, if you look at paragraph 71 through 73 of our skeleton argument, and if you look at paragraphs 77 and 78, and 80.
I don't see how any of those make the slightest difference. None of them say that if I take something away from the corporation, I'm not taking their property.
Well, my lord, as I said, I'll come back to that because I'll confer with those that are with me. But my view and the way we argue this is that as a result of the source of the funding, that there was a difference in the way that Section 13 would be applied. But I'll come back to that.
Okay, fine.
So, Lord, the first case is the case of Lawrence. And just trying to find where my Lawrence is. I think I have the wrong numbering for my Lawrence. What tab number?
47?
47? Oh, I have it, different tab number. Ah, that's right. Okay. Right,
So 47, are we?
that's where we are, 47, Lawrence. Lawrence is Court of Appeal decision in the Eastern Caribbean. It's decided in 1983. The facts actually are quite important. The learned Chief Justice in his ruling actually distinguished the facts. So I should go through them so that you can see how he arrived at his decision. Lawrence was managing director and chairman of the board of directors of the Kitts Anguilla National Bank. On the 8th of March, the House of Assembly passed through all its stages a bill which received the governor's assent, same day and became the St. Kitts National Bank. On the afternoon of the same day, 6 members of the police force, including the Commissioner of Police, entered the head office of the bank and purported to hold meetings there. On the same afternoon, Edmund Lawrence received 3 letters, one from the Minister of Finance, purported to remove him as director of the bank. Others signed by a chairman of the board notified him that a new board of directors had been appointed under the Act and the board had decided to terminate his services with immediate effect. On the 15th of March, Edmund Lawrence applied to the High Court under the then Constitution Section 16, claiming redress for an alleged contravention of Section 6, which protected property rights from compulsory acquisition. The High Court Bishop J granted declarations that the Act contravened Section 6 and was therefore unconstitutional and void, together with the purported appointment of directors, their assumption of control of the bank and their dismissal of the applicant. Held, item 2 of what was held is important. Property rights in which are protected by the Constitution, Section 6, should be given a wide and liberal construction to include not only concrete rights of property, but also abstract rights such as rights of management of a company. And then, if I can ask you to turn to page 926, letter G.
Yes.
From the afternoon of the 8th of March, 1982, the Minister of Finance, on behalf of one shareholder, the government of the state holding 60% of the shares, could appoint a majority of the directors to the board of directors. Immediately before the act became law, the directors were appointed by the shareholders. And then,
Wait, what, did you say 9? Oh, yes, I see. Right. Oh, sorry. Yeah.
Sorry, is it 926?
Yes.
926, letter G.
G.
It's closer to H, but it is G. Yeah.
Yeah.
Could you?
Oh,
That doesn't seem the right reference.
926.
Well, I think it is, but it's the G that's confusing because G begins at number 8 of 1982. If you go to the next sentence, it's from the afternoon of 8th of March, the Minister
Right.
of Finance.
Got it. Thank you.
And then on page 928, now at the foot of 927, you can see that they're dealing with the judgment at first instance. And at top of the page, they refer to section 6.5 of the Constitution. And then on page 929, in between paragraph B and C, starting first of all, in fact, if we start at B, I propose to deal with these two aspects in reversed order, as in my opinion, it is first necessary to find whether Lawrence can allege an infringement in relation to him. In other words, whether his application is well founded in relation to himself. This he must first show. First of all, we know that he was a director and a shareholder. Further to this, we know that he was not paid, just a paid employee of the bank, and that he drew a percentage of the profits annually. At one stage, this was as high as 50%. We know that this was subsequently varied, but it is not my understanding that it is being alleged that he ever became a mere paid employee of the bank, and it is reasonable to infer that his original status continued, perhaps at something less than 50%. So in this case, in ruling that there had been a breach of the provisions of the St. Christopher and Nevis Constitution, the important point is that there had been a taking of his profits from his directorship and shareholdership of the bank. And this is the basis upon which the learned Chief Justice distinguished this case from the instant case. There had been an actual taking, an acquisition of what was his interest that he no longer would receive. The next case is at tab 23.
Just forgive me, what was the right that he was relying on in
Section 6.5, or deprivation of property under the
right.
Constitution of St. Christopher and Anguilla, Section 6.5. I think I referred to that on page 928.
Sorry, we're in tab 23, are we?
No, sorry, we're still with Lawrence.
Right.
I wanted a page reference in Lawrence.
Well, it's true that at the top of page 928, he says, I come now to section 6.5, but section 6.5 is nowhere set out, but it's a deprivation of property section.
Yes.
Well, wait a minute. Slightly puzzled about that. If you go to the head note at 921, second full paragraph, on the 15th of March, Edmund Lawrence applied to the High Court under the then Constitution, claiming redress for an alleged contravention of Section 6, which protected property rights from compulsory acquisition. Not the same as deprivation of property.
And I think that the learned Chief Justice, I'm not sure whether he distinguished it on that basis. He certainly distinguished it on the basis that there had been an actual taking of property. I believe this, in fact, let me see if I can find.
And Lord, I'm sorry to interrupt, but just so that we can deal with this while we have the case out. Would you mind reading the first paragraph on page 931?
931. Nine which one?
View that section 6 applies equally.
Sorry, which page?
Page 930 at B. I would hold that management is an important incident of holding property.
I'm not sure.
Well, I don't want to interrupt you. I'm sorry. I just wanted to, for completeness.
Or do you need any further reference to that case?
Well, I do. I'm not clear.
Okay.
Because we haven't got the relevant provision of the section, whether or not what the Chief Justice found was that there was a taking of property or a deprivation of rights of management.
Well, when we look at the decision, so Lord, the reasoning of the court is short. It starts at 928, letter G. Nothing before that is the court's reasoning. And
Well,
so
I follow that, but I find it difficult to know what the court's reasoning was without knowing what was the provision that it was applying. You see,
they're not set out more. They're not set out. I mean, they're not set out in the decision anywhere. Lord, I only rely on the case to distinguish it. For our purposes, this is not one of the cases that we rely on. Certainly, I think my friends rely on it. The Chief Justice distinguished it on the grounds that there was an actual taking of property. So, Lord, I'm sure we may be able to assist at some point in getting the Constitution.
That's even more confusing. Was there if what happens is that a man is entitled to 50% of the profits annually, and he's dismissed from that job, so he's not entitled to it at all, I find it difficult to regard that as a taking of property. He is deprived of the property that he would otherwise have enjoyed.
Lord, let's look at how the Chief Justice considered this.
Yeah, let's do that.
The ruling is at tab 8, commences at page numbers 1187.
Yes, could you give me the paragraph number?
Yes, I'm just looking for it now.
Excuse me.
Well, at page 1246, paragraph 109.
Right.
Yeah. Yes.
So
At page
it's
110, Mr. Lawrence, second sentence, third sentence. Mr. Lawrence challenged the validity of the Act based upon Section 6 of the Constitution of St. Kitts, materially identical to Section 13(1) of the Bermuda Constitution, alleging that he had been deprived of property by the government without compensation. Though in fact, 13(1) of the Bermuda Constitution doesn't in terms deal with deprivation, it deals with compulsory acquisition.
I think I just want to make sure that the Chief Justice gets the quote in paragraph 110 from page 930, and it's an exact quote that he takes from the case. I don't think there's much more you can get from the case. There's no.
Lord, I'm sorry, can I just interrupt 1 minute? If you look at 54G, which is the first instance judgment, the first instance judgment sets out things in much greater detail.
Sorry, we look at what?
Tab 54G, which is the judgment of the Bishop J in the first instance court.
Right.
I'm not sure how to. On page 12, I think it is. It's 12 of. Yes, page 12. It sets out the section.
Sorry, I've got to find the thing.
I'm sorry.
I have got to find the thing because it's not in the bundle. It's on the cloud.
54G is not in the bundle, my lord.
It's not in.
It's not in the bundle. It's a subsequent.
So we have to go onto the cloud to find it, which is very tedious.
Oh, I'm so sorry.
Only added later. Mm,
Section 6.
right. Right, I have found it now. What shall I look at?
If
Page
you
12.
look to page 12 sets out the section that was being relied upon. Page numbers are very small at the bottom right-hand corner.
Mm. Just a moment. Yeah. Yes. So as I thought, the section deals with compulsory acquisition, compulsory taking possession, or the compulsory acquisition of an interest in or right over property.
Right.
I won't use the expression deprivation.
That's, I think, the expression the Chief Justice has used.
The expression the Chief Justice used. It's not the expression the legislature used. And as we have seen, there's a potential difference between deprivation and compulsory acquisition. And you don't accept that compulsory acquisition can be interpreted by reference to section 1 as including deprivation.
Not deprivation as in the depriving and taking as separate enforceability, no.
Right, so it's necessary to look at what the statute says.
Right. So the main distinguishing feature we rely on with respect to that case is exactly how the Chief Justice treated it, namely that there was evidence of a contravention of an equivalent provision to our section 13, but it was on the basis that there had been, quote unquote, a taking of the property that would equal the 50% of the shareholding interest that he would receive through dividends.
Well, that's not true, Mr. Duncan, I'm afraid. That's not correct. Sorry, I think that's misleading.
Okay,
Anyway,
you go ahead. You go ahead.
The fact that the court found that rights of management were rights of property which had been taken demonstrates conclusively that the only property at issue was not just shareholding, because shareholding is not about rights of management. Further, if you look at the first instance judgment, you will see that the action was commenced by the bank, and the only interest the bank had was the interest in its management. The issue about standing, which you were just looking at, the reason why the court was looking at whether he had standing first, I think they put it, is because they wanted to see whether he had standing also on behalf of the bank, which they held he did have as a managing director. That's where rights of management came in. So I don't think it's true to say that it's limited to his property and his shares, because his property and his shares, it doesn't relate to issues of rights of management. That's all I'm saying. I just don't think that's the correct understanding of the case. Sorry to interrupt.
So what appears to have happened so far is that in St. Christopher's, the judge at first instance and on appeal had decided that the deprivation of rights of management fell within the purview of Section 6 of the Constitution in circumstances in which the Constitution doesn't refer to deprivation, but does refer to the compulsory taking possession of an interest in or right over property, when in fact the right of management could be said to be a right of which the putative manager was deprived. It wasn't a right which the authorities in St. Christopher and Nevis had acquired.
I'm not sure I get the point, my lord. I'm sorry, I misunderstood you.
Well, let me try again.
Yes, please.
What appears to have been held is that the judge was right to conclude that the deprivations that Mr. Lawrence had alleged fell within the purview of Section 6. And the deprivation concerned was management, because that was, so the court in St. Christopher's held, was an important incident of holding property.
Mm-hmm.
So the deprivation of the right of management fell within the purview of Section 6.
Yes.
Well, that's what they found. One then looks at Section 6, and it says, no property of any description shall be compulsorily taken possession of, and no interest in or right over property shall be compulsorily acquired. Assume for a moment that management is an incident of property. The property namely the management, how can that said to have been taken possession of or compulsorily acquired by the government, as opposed to Mr. Lawrence being deprived of the right of management that he once had because he was sacked?
My lord, I think the way that it was argued was that the bank had a right to manage its own affairs. The government came in and took away that right. That right to manage its own affairs was held to be a proprietary right. Because don't forget that this case was launched by the bank and Mr. Lawrence, and it was the bank's case. The bank initially asked for a declaration that the takeover, if you want to put it that way, was contrary to the Constitution because it was taking away from them their right to manage their own affairs.
I see. So the government had taken over the management
Of the bank.
It wasn't simply that Mr. Lawrence had been sacked. It was the fact
Correct.
that the government had I follow.
You see? So the statute converted the bank, very much like this case, into a sort of a governmental entity or governmental control
Yes,
entity. You see?
Yes.
Thank you, madam.
Right. Okay. Right.
Mr. Myers, have you finished or?
I have indeed.
Okay. If I can move to the next case. Just bear with me one moment. My list of cases. The next case is the Compania case, and that is at tab 23.
Yes.
I don't think this case, thank you, corrected, but I don't think that this case was cited in the judgment. Of the Chief Justice. This case was referred to by my learned friend, Sir Geoffrey. Let's just go back to page 495, what was held. When considering whether legislation had violated the property rights of landowners protected by the Constitution, the correct approach was to read sections 3C and section 8 thereof together. Notwithstanding their close relationship, there was a distinction between the protection provided by 3C and section 8.
So where are you reading from?
Page 495, what was held.
Sorry, 495 of what?
Tab 23.
Sorry, what item is, oh, I see. Okay. Yeah, right.
Right. So this is the La Campagna case with the government of Mauritius. This is the case that was referred to by my learned friend during the course of his submissions. The important point to note about this case is that it is a case involving the government of Mauritius, the Mauritius Constitution. So section 3C and section 8 are both enforceable in their own right.
Yes.
And so the court says that section 3 was a more general provision recognizing the right to protection against deprivation of property without compensation, such protection being qualified in general terms. Section 8 set forth the circumstances where property and interest in property could be acquired compulsorily, provided such property or interest was sufficiently identifiable to be capable of acquisition. And those are the important words. In the instant case, although the restrictions which section 5A placed on contracts gave the right to renew his contract, required planters to re-let to a matea and confine use of the land to the growing of sugarcane, these could not, even on a generous interpretation, be considered as the compulsory taking possession or acquiring of a right in or an interest over property, which was the subject of the protection provided by section 8.1. The increased control of land, which section 5A involved, did not contravene the section 3 protection by lack of any provision for compensation, since a fair balance between the interests of the community and the rights of the individuals whose property's rights were adversely affected had been achieved, which was a question of fact and degree for the court, which would be allowed a substantial margin of appreciation. And one important point that we see there that I'll come to later is the application of the margin of appreciation to an enacting provision, which has similarities with our section 1, but I'll come to that later. And then we see on page 500, there's a reference to the construction of section 3 at paragraph H, and it relies on Society United Docks. And then at page 501, the correct approach is therefore to read 3C and section 8 together, with the relevant language of each influencing the interpretation of the other. And then in the middle of paragraph F on that page, the property or interest in property must be sufficiently identifiable to be capable of being taken possession of or acquired in this way. However, once property to which Section 8 applies is compulsorily taken or acquired, then the section is contravened unless all requirements of Section 8(1)(a), B, and C are fulfilled, or one of the other limited exceptions in Section 8 applies. The qualification and the protection provided by Section 3 is in much more general terms. There is therefore significant distinction between the protection provided by Section 3C and Section 8, notwithstanding their relationship. So that's what the Constitution of Mauritius has said, with a Section 3 equivalent to our Section 1 that is separately enforceable. We then turn to the case of Panton, which is a 2001 case at tab 48. So Panton, tab 48. And Lord, you'll see from paragraph 120 of the judgment of the Chief Justice that he uses the case of Panton to distinguish the case of Lawrence. Come to that shortly. So let's first deal with the case of Panton, and then we can see how the Chief Justice treated Panton and Lawrence together. Panton is a case in Jamaica. It would be under the pre-2011 Constitution. The facts of the case are that the appellants were shareholders in 3 financial institutions. Following investigations into the activities of one of the institutions, the Minister of Finance and Planning assumed temporary management of the 3 institutions under Section 25 of the Financial Institutions Act 1992. The appellants then commenced proceedings claiming that the provisions of the 1992 Act and consequently the actions of the minister were unconstitutional since they amounted to the compulsory acquisition of property without compensation, a right protected by Section 18 of the Constitution. Proceedings were dismissed by the Constitutional Court, and the appellants appealed to the Court of Appeal presided over by Rattray P, who dismissed the appeal. The appellants appealed to the Privy Council on the substantive question on the grounds that they had been denied an independent and impartial tribunal. There's a big argument on bias that we don't have to concern ourselves with, and that takes up questions 1 and 2 in the findings on page 133. But we can go to page 134 and see what was held in number 3. To establish their claim under Section 22 of the Constitution, the appellants had to show that the action of the minister under Section 25 of the Financial Institutions Act constituted a taking of property. However, what the minister did was to take control over the company. The appellants remained shareholders, and none of their property, including their shares, had been taken away. Equally, no one had been dismissed, and thus no one had property taken in the sense they were removed from office. Ultimately, the statutory provisions were regulatory rather than confiscatory, and therefore no obligation to compensate arose. And you'll see exactly what the Chief Justice did is what the court did in Panton. They distinguished the case of Lawrence. And so much of the case is dealt with the question of bias. It's with respect to whether or not the Attorney General, who later became a judge, was involved in the decision to create this legislation. But then, my lord, if you turn to paragraph 21 on page 142. The legislation makes no provision for compensation in a case where the minister assumes temporary management of a license. The appellant claimed that that constitutes an infringement of section 18 of the Constitution. The point here is a short one and admits of an immediate answer. The appellants have to show that the statutory provisions constitutes a taking of their property. But what the Act empowers and what the minister did was a taking over of the control of the company. The appellants were and remain shareholders of the company. Their shares would doubtless qualify as property, but their shares were not taken away. They no longer had the control of the company, which was inherent in the shareholdings which they possessed, but the assumption of temporary management by the minister did not involve the taking of any property of the appellants. That the regulation of the company was in the hands of the minister did not mean that the appellants had had any of their property taken away from them. A comparable situation can be found in Belfast Corporation, where a restriction imposed by a local authority on the use to which land could be put was held not to be a taking of property without compensation. As Viscount Simon said, that anyone using the English language in its ordinary signification would surely deny that any of those rights which in the aggregate constitute ownership of the property could itself and by itself aptly be called property. And to come to the instant case, he would deny that the right to use property in a particular way was itself property, and that the restriction of denial of that right by a local authority was taking away or taking over of property. The appellant sought to found upon Attorney General of St. Christopher and Lawrence, but that case concerned the removal from office of one who was not only a shareholder, but a managing director who drew a percentage of the profits from the business. In that case, a taking of property could be identified. In the present case, no one has been dismissed and nothing had been taken. The shareholders remained holding their shares. The statutory provisions were, as the Court of Appeal recognized, of a regulatory, not a confiscatory nature, and no obligation for compensation arises. So, my lord, a few points arise from that case, and this may be where some of the, I don't want to say confusion, misinterpretation, however you want to put it, arises. This is how the Privy Council described the case of Lawrence in paragraph 143F, which is what I had said earlier. Their construction of what happened in Lawrence was that it was a taking of property that could be identified.
Just help me on that. We've now moved away from management, and it said there's a taking of property because the managing director was no longer entitled to a percentage of the profits from the business. That was plainly a deprivation on the part in relation to the managing director, because he no longer got the profits. He was deprived of them. But how was there a taking of property?
Well,
I suppose they took from him the right to get the money.
It depends how you're using the word. I mean,
I know.
Yeah, but my lord, the fact that there may have been quote unquote a deprivation doesn't mean there wasn't a taking, in the sense that I think the Privy Council was saying in this case, he lost the right. That right was taken away from him to acquire those profits.
Yes.
And I think that's the sense in which the Privy Council meant that on page 143. Now let's look at how the Chief Justice treated this. The Chief Justice considered Panton in paragraph 120, but in fact, he starts at paragraph 112. And what he says, and we adopt this reasoning, is that the issue whether taking control of the management of the company amounts to taking a property of the company was addressed by the Privy Council in Panton. And he goes through that. And then on paragraph 113, he says the Privy Council did not accept that the mere taking control of the management of a commercial enterprise amounts to deprivation of property of the owners of that enterprise. And he quotes what I've just read from Lord Clyde. And then paragraph 114, he says, in Panton, the appellants expressly relied on Lawrence and argued Lawrence was an authority for the proposition that mere control of the management of a commercial enterprise amounts to taking of property. That point was expressly rejected by the Privy Council in Lawrence. And Lawrence was distinguished on the basis that Mr. Lawrence was not merely lost control of management of the bank, but lost the prospect of obtaining up to 50% of the profits generated by the bank. It was the loss of profits which amounted to the taking of the property. And that's, I think, feeding into the words that Lord Clyde used at paragraph 22. And then in paragraph 115, and we would endorse this finding, the Chief Justice says, in my judgment, Panton, which is binding on this court, is authority for the proposition that mere loss of control, even total loss of control, does not amount to deprivation of property. There must be taking by reference to loss in the value of identifiable property. This was the basis upon which the Privy Council distinguished the decision of the Court of Appeal in Lawrence. Here, the corporation as a legal entity continues to own the assets as before, and there is no suggestion there has been any diminution in the value of those assets. I'll come back to Papanet after I've gone through that case. And then at paragraph 120.
Sorry, can I just be clear? Are you saying that an impairment of property rights isn't deprivation?
Not unless there is a taking that is substantial or an inability to use those property rights to a degree, the cases say, that actually amounts to a taking or an acquisition of that property.
So if you transfer the rights to someone else, is that not impairment and taking?
It depends. If you're talking about transfer the rights in this case, I would say no, because there's still ownership of it depends what you mean by rights. There's still ownership of the property. So the only way that a transfer of an assignment would take away property is if the person no longer had any ownership, use, control, or exercise of any function over that property. So they really were divested of it. But that isn't what this case is. In this case, the property still rests with the corporation.
But their powers in relation to it are emasculated, or at least that's the allegation.
But they're still owners of the property. And it may be that they act on the direction of the government, but they still own the property.
But the fact that I still own my house, but I have to exercise my rights to occupy my house or to deal with my house as dictated by the state, thoroughly emasculates my rights in relation to the property, doesn't it?
Well,
And deprives me of valuable rights in relation to my property. If I can't say who's to live there, or I've got to allow other people to live there, or I've got to paint it a certain color, that emasculates my rights in relation to my property and deprives me of the enjoyment of my property.
well, in that circumstance, maybe, but in this circumstance that we have, the corporation is not deprived of the ability to make decisions with respect to the property that they have. They just have to make decisions with respect to the property with the consultation of the government. But that doesn't deprive them.
It's approval, it's not consultation, is it?
Well, it says consultation in the legislation. Subject to consultation. That's
I thought it had to be approved by the government as well, doesn't it? Resolutions have to be approved, don't you?
Right, but they're subject to consultation, and
Yes,
the
but
consultation.
also they have to be approved.
Sorry.
They have to be approved
Right.
and not to take effect unless and until they're approved.
Yeah.
Right, but in my view, my lady, that is not based upon the cases of deprivation of property because they still own the property. The property is still vested in them.
Well, that's not much use if you're talking about, say, a domestic property and, okay, I still own the title deeds to my house. It's still registered in my name, but my family and I aren't allowed to live in it, or we have to live in one room. And I have to allow other people to live in the rest of the rooms of my
Well, that's not this case, my lady. That's not this case.
Right, okay.
And I'm
Not
Sorry?
yet this case, not yet this case. But the minister has a very large power, which includes being able to tell the council to do anything.
Well, we'll come to that. We
Okay.
don't necessarily agree that the interpretation of telling the minister to do anything is correct. We deal with that in our rule of law argument that I'll come to with respect to section 7AA. There are constraints, and the reality is those constraints are meaningful.
Right.
But I mean, just finishing off, responding to my lady, the authorities make it quite plain that unless, the corporation will remain in ownership, they will remain in possession, they will remain having use of the property. Yes, the management rights may have been superseded by the legislation, but there has not been a taking. And in fact, I just read, and I'm not going to reread, but just reading paragraph 22 in the case of Panton, and the reference to the Belfast Corporation case. Viscount Simons makes it quite clear. What we have to do is, I say with respect, not listen to the high-sounding claims of criticism of what this legislation will impede the corporation from doing, and look at the authorities and look at the fact of what actually the corporation still will have and what they will be permitted to do.
Well, let's have a look at Belfast Corporation, which is at 143 of Panton. The restriction imposed by a local authority on the use to which land could be put was held not to be a taking of property without compensation.
Right.
Assume that to be right. Viscount Simons stated that anyone using the English language in its ordinary signification would surely deny that any one of those rights which in the aggregate constituted ownership property could itself and by itself aptly be called property, and to come to the instant case, he would deny that the right to use property in a particular way was itself property, and that the restriction or denial of that right by a local authority was a taking away or taking over of property. So he's dealing there with whether there was a taking of property without compensation.
Right.
In the constitution with which we're concerned, the question is whether there's a taking of possession of property or the acquisition of a right or interest in property. And isn't the right, to take my lady's example, of the person who owns property to determine who shall live in it, a right or interest in property?
Well, it depends how you look at that. We would say no, and the reason we would say no is because of the protections that are put in place, the protections via consultation. They can challenge a decision if that is exactly what is being done. But as things stand now, there has been no transfer of ownership.
But I'm sorry, we can't, we don't think we can approach the matter by only looking about what has happened so far, because the case that is made against the government is that the powers that it has taken mean that in future it is capable of acquiring property without, or possession of property, or rights in property without compensation. So to say, well, nothing has happened so far of that kind is true but uninteresting, it might be thought.
Lord, yes, but we say that the fact that there may be a potential, or I know my Lord says it's uninteresting, but the reality is it's speculative at this stage. The determination shouldn't be made based on that at this stage.
Well, is that right? If the position is that the legislation passed gives the minister power to do that, which if he did it would be unconstitutional, aren't we to say that?
Well, we say, and this is foreshadowing the argument I'm going to make with respect to the rule of law, we say that the interpretation of the constitutional provisions, particularly section 13, has got to be seen in the context of the minister only being permitted to do what is lawful. He is only permitted to do what is lawful and only permitted to do what the functions and the activities that he can direct the corporation to do are those that are laid out in the municipal acts. That's all he can do.
Well, we'll come to that in a moment.
And so for him to direct unlawfully the taking of property would not be within the terms of the legislation, the municipal acts and all the amendments. It would have to be a lawful taking.
Don't follow that, because the power given to him to do that is in one of the municipal acts. You seem to be creating a set of municipal acts before the acts complained of, and saying that the minister can't do anything which isn't consistent with those acts, when the problem is that the government has amended the municipal acts by endless amendment number 1, amendment number 2 acts, so that now the municipal acts include an entitlement of the minister to tell the corporation what to do.
Lord, I'll come to that, but we interpret that differently. We say that there is a restriction on what the minister can do. And there are a number of authorities that we will come to that support that. And I do want to have an opportunity to come back and address the question that was directly asked by my lady with respect to whether or not the assumption or transfer of rights would amount to a breach of section 13.1. I do want to come back to that.
And Mr. Duncan, when you come back to that general question, I mean, if, by way of example, the government gave an instruction to the corporation in relation to the waterfront, and as I understand it, the government now receives the wharfage, which previously went to the Corporation of Hamilton, and provides that the corporation should have a fixed amount, which the corporation says is a great deal less than it received by way of wharfage. So is that not an example of what has happened of the sort which could happen in the future?
Lord, as I said, I'll come back to that point.
Right.
Thank you for bringing that to my attention. So the next case, which we've been through on a number of occasions, is Campbell Rodriguez. Before I come to that, I should just leave off with taking you to paragraph 120 of the Chief Justice's judgment. That's the final reference to Panton. And you'll see that the Chief Justice relies on the case of Panton and says that case clearly holds that assumption of management control without more does amount to deprivation of property. Significantly, the Privy Council in Panton distinguished from Lawrence the main case relied upon by the corporation on the basis that the loss of property in that case could be identified loss of up to 50% of the dividend from the bank. In the circumstances, I am satisfied that the corporation's challenge based on section 13.1 of the Constitution cannot succeed. Well, that's how he dealt with Panton, which we would endorse and support. The next case is...
Just help me on this. I'm puzzled by this paragraph. He says that the corporation's challenge is based entirely on the basis of control exerted by the central government over the affairs of the corporation. The corporation accepts that this is not a case where there has been any transfer of property from the corporation to the government. But did the submissions not below not consider what the position could be? In other words, what the minister was entitled to do by way of transferring property from a corporation to the government or anybody else?
No, my lord, that wasn't.
No.
Lawrence? No, that wasn't the question below.
I'm sorry, the issue of control was hammered below. And control involves the idea that the minister can tell you to do anything you like with your property, anything he likes with your property. That was hammered.
Lord, I am instructed that that point, I mean, I know Mr. Myers, Mr. Sadler-Best is sitting with me.
But it's really quite...
That point wasn't made below.
It's in written submissions.
And we have those submissions that Mr. Myers no doubt can take.
You do indeed, my lord.
Right. Well,
I was going to say, Mr. Myers, you can no doubt point to the part of those submissions that supports your argument.
I will do in shortly, my lord. Let me just have a look.
Right.
Yeah, what I'm being told is that what was, there's a difference between what was in the written submissions, and we're not sure what's in the submissions, Mr. Myers will find that, and what was actually argued. What was not argued is the point that's being put forward now by my lady and the president. That was not argued. That's what I'm being told.
Say somewhere. For example, in paragraph 3 of the submissions at Annex 1, paragraph 3, Annex 1.
Yes, as appears from the main Gosling affidavit.
Correct. The effect would be to place the corporation and its property under the complete control of the government. That is saying that what this legislation will permit the government to do is to control the property of the corporation.
I mean, I don't know how we're going to finish on like this, but my Lord, that isn't the question that was put. The question was put about the assignment or transfer of property, and the question was asked whether that was dealt with below, and it was not argued. Now,
the whole point was that the corporation's ability to deal with its property would be adversely impacted by the government's overarching control. That was the entire point of the case.
Well, let's get on for the moment. I don't see how we can usefully address the issue without considering the possibility of the minister ordering a transfer.
So, Lord, let us look at the case of Campbell Rodriguez.
Is there anything in there we haven't already been taken to?
I don't know, but I'd certainly like to make submissions on it unless the court doesn't want to hear those on Campbell Rodriguez.
Well, no, tell us what you want to say.
Okay, thank you. Tab 14. And you'll see that at page 527, paragraph 2, there could be a taking of property in relation to section 18 of the Constitution, which was neither a direct physical appropriation of property nor an ouster of possession. Moreover, it was not necessary to show that there had been a transfer or change of ownership or possession from one person to another or body. It was established that taking was not limited to direct appropriation of property, but could encompass regulation of the use of land which adversely affected the owner to a sufficiently serious degree. However, it's equally well recognized that states could pass legislation regulating the use of land in the public interest, which did not carry the right to compensation as a taking of property, even though such regulation could have significant adverse economic effects for property owners. Furthermore, measures adopted for the regulation of activity in the public interest, such as planning control or the protection of public health, would not constitute the taking of property, notwithstanding that they might have an adverse economic effect on the owners of certain properties. In the instant matter, the appellants could not establish that the construction of a new road and the charging of a toll for the use of for its use constituted a taking or acquisition of any property right capable of coming within Section 18 of the Constitution. Therefore, the appeal would be dismissed. The sections dealing with taking of property are on page 535 and 536. And starting at paragraph 17. And you can see that there is a reference to United States authorities with respect to regulation of the use of land and that impact on taking. It is equally well recognized that states may pass legislation regulating the use of land in the public interest, which does not carry the right to compensation as a taking of property, even though it might have significant adverse economic effects for property owners. The American cases are constantly cited in this context. Examples may be found from other jurisdictions. It may be necessary to use such authorities with a degree of caution, bearing in mind the differences in the wording of the applicable constitutional provisions. But a common thread is visible in a number of the developed systems. And then there's a reference to Belfast and the fact that Viscount Simon cited a decision from the United States to come to that conclusion. Every restriction upon the use of property imposed in the exercise of the police power deprives the owner of some right, therefore enjoyed and is in the sense an abridgment by the state of rights in property without making compensation. But restriction imposed to protect the public health, safety, or morals from dangers threatened is not a taking. The restriction here in question is merely the prohibition of a noxious use. And then over the page, commencing the third line, talking about the cases on regulation, and the court says they establish clearly that there are limits to the concept of taking property, and that some types of state action which could linguistically be so regarded are not to be regarded as justiciable. It is well established that measures adopted for the regulation of activity in the public interest, such as planning control or the protection of public health, will not constitute the taking of property, notwithstanding the fact that they may have an adverse economic effect on the owners of certain properties. So in the Jamaican appeal of Panton, the board held that the assumption under statutory powers by the Minister of Finance of the temporary management of certain companies, and we've seen that. Paragraph 19, their lordships regard the analogy as persuasive. The project involved the replacement of an inadequate public road and bridge by an improved road and a new bridge designed to inure for the benefit of the public in general by the speeding flow of traffic and relieving congestion. It was to be financed not by the taxpayers as a whole, but by charging tolls paid by those using the road. Their lordships considered the words of Viscount Simons were apt when he asked rhetorically whether anyone using the English language would say this meant the authority had taken property. The appellants cannot, in their lordship's opinion, establish the construction of the new road and the charging of a toll for its use constituted a taking or acquisition of any proprietary right capable of coming within Section 18. And then the last of the cases, which was also referred to by the Chief Justice as Pamponet. And Pamponet is found at tab 6. Let me just check. Tab 49.
49.
Tab 49. Now, we submit this case has to be read in context, and the learned Chief Justice does that in his ruling. This is a case as much about legitimate expectation as it is about the taking of property. In this case, the appellant owned a taxi permit and operated that taxi permit, which the government took under promise of giving compensation. But instead of giving compensation, the government gave the permit to the appellant's competitors and made regulations for entrenching the competitor's right to use that particular grant. And so in this case, we can look at page 10. Where they seek guidance from the European Court in terms of how to interpret the provision of the Constitution in Trinidad and Tobago that deals with the taking of property. They refer to the case of Tractor. In that case, the applicant's license to serve alcohol at its restaurant was revoked. It was contended there had been a breach of Article 1 under the European Convention, which provides, and we have that, and then paragraph 21, paragraph 53 of its judgment, the Court of Human Rights rejected the argument that a license to serve beverages could not be considered a possession within the meaning of Article 1. They held that the economic interests connected with the running of the restaurant were possessions, and that the withdrawal of the license had adverse effects on the goodwill and value of the restaurant. Such a withdrawal constituted an interference with the applicant's rights, peaceful enjoyment of its possession. Warner J. said at paragraph 62 that a critical factor in that decision was that the withdrawal of the license directly affected the company's business. The operation of the business was not possible without the license. And one of the things I think that Chief Justice did in distinguishing this case is saying that the corporation will still be able to carry on its activities. And then it goes on to say that paragraph 23, well, let me read what Warner says. I've gathered from the authorities that the interference complained of must be substantial to amount to a deprivation. If therefore an applicant can still put his property to use, then the challenge will not succeed. She concluded that the fact that the members of the association were subject to the management control of the PTSC and had put to pay a use fee was not a sufficient interference with their property to amount to a breach of their Section 4A rights. Broad does not agree with this conclusion. In order to prove an infringement of the right to enjoyment of property, it is not necessary to show in a business context the infringement makes the operation of the business impossible. That was not the effect of the Tractor decision. The infringement must, however, reach a certain level of significance. The regulation cases such as Tractor could be applied with some care. In many of the cases relied upon by the Court of Appeal, the principle that was being applied was not that a regulatory restriction could not of itself involve the taking of property. Rather, it was that, as Lord Hoffman put it in Great Bay, it is well settled that restrictions on the use of property imposed in the public interest by a general regulatory law do not constitute a deprivation of that property for which compensation should be paid. Indeed, in the Tractor case, the Court of Human Rights said that the withdrawal of the license to serve alcohol constituted a measure of control of the use of property which falls to be considered under the second paragraph of Article 1. It concluded that withdrawal of the license was done in the public interest in furtherance of the social policy of controlling the sale of alcohol. It was not necessary for the applicants in the present case to show that the effect of the regulations pursuant to the 1977 order deprived them of their business altogether. There is no warrant for interpreting Section 4A of the Constitution in this way, any more than Article 1 of Protocol Number 1 of the European Convention. The interference with their business was substantial. They had previously managed control of affairs. Now they were subjected to the control and management of their competitor, who, pursuant to the authority conferred by the regulation, charged them a fee for every exit journey and decided whether they were fit and proper persons to be granted to permit to use the city gate facility at all. Prima facie, therefore, there was an infringement of the members' Section 4A rights in these circumstances of the government to justify the interference being in the public interest. If they failed to do so, the breach was established. So in that case, the Chief Justice interpreted Papanet in paragraph 116 of the judgment. Paragraph 116 of his judgment. And he says the applicants were members of an association. We know the facts. In 1995, the government proposed moving the taxi stand for their routes to a new location at a transit center on the land owned by P Corporation. And then over the page, he says that and then in paragraph 117, the applicant sought declaration that the government's conduct contravened their right to enjoyment of the property as guaranteed under Section 4A of the Constitution. Lord Dyson referred to the Tractor case. The court held that the economic interests connected with the running of the restaurant were possessions, and that the withdrawal of the license had adverse effects on the goodwill and value of the restaurant, that it constituted an interference with the applicant's peaceful enjoyment of its possession. And then he cites Lord Dyson, paragraph 23, and we rely on his distinction of the Papanet case. He says here in paragraph 118, the interference with the business of maxi taxi owners and operators was substantial. First, they had previously managed and controlled their own affairs, but now they were subjected to the control and management of their competitor. Secondly, pursuant to the authority conferred by the regulation, the competitor charged the maxi operators and owners and operators a fee for every exit journey. Thirdly, under the regulations, the competitor decided whether the maxi taxi owners and the operators were fit and proper persons to be granted a permit to use the facility at all. And then he quotes Lord Dyson. And in paragraph 119, he says, the facts in Papanet bear no relationship to the allegations of existing control and proposed control of the corporation's affairs made by the corporation in this case. None of the three factors in the Papanet case mentioned in the previous paragraphs, which form the basis of the finding there was a breach of Section 4A rights, are present in this case. The allegations of regulatory control made by the corporation in this case are very much in line with the allegations made in the case of Panton. And we would support that reasoning of the Chief Justice. So I have two questions to come back and answer on this point, but we say that based on our initial submissions and the authorities, the Corporation of Hamilton, I think I should take you to my skeleton now because we said it out, didn't we? Paragraph 69. And 70. and 71. And then in paragraphs 72 through to 83, we set out the limits on the corporation's powers.
Where are we looking at?
So the submissions on deprivation of property, I directed the court to paragraphs 69 and 70. And then as far as the status of the corporation and how that feeds into the deprivation of property argument, we say that its status is relevant because of its regulation under the relevant legislation. It is not, it is a statutory created body with limited powers that are referred to in sections 73 through to 80 of the skeleton argument. I will come back to and take some instruction, but I'll come back to the 2 points that I was asked about with respect to the potential of a future taking of property. Lord, I would like to move on to what I call the section 9 point, which is the new point.
May I just interrupt really quickly, Mr. Duncan, just for their lordship's note in relation to what was submitted below on the minister and what he might do. See on this Annex 2, page 5, middle bullet.
Annex 2, page 5.
Yes.
Middle bullet.
Middle bullet. It says, again, in relation to land, and then it goes on to say, the minister may issue mandatory directions for corporation to do any act or thing. And once having given such a direction, the act or thing is deemed to be for municipal purpose and deemed to be a function. There is nothing in the statute to prevent the minister from directing the corporation to carry out works on its land which benefit the government or any member of the government and not the corporation or its ratepayers. And such works will be deemed to be for municipal purposes and a lawful function of the corporation. Indeed, there's nothing in the statute to prevent the corporation from transferring its land or works to the government or any third party.
I think Sir Geoffrey took us to that before.
Yes, I'm just pointing out that this actually was submitted, contrary to what is now being suggested.
But Lord, I didn't interrupt either of my friends. I do think it's highly inappropriate. I really didn't.
I'm so sorry.
There were many occasions when I could, with respect to the section 1 point, and I'm a little bit disappointed that the time I had is being eaten up and I didn't do anything with their time. The point I made is this: I'm not sure where it is in the submissions, and my friend is, the issue is whether it was argued before the court. That was the point I was making.
Yeah, you made that.
We'll apologize deeply for any discourtesy, but I think we meant it entirely as a question of joining the debate, but we do accept your point.
Apology accepted. Thank you, Sir Geoffrey. If I can move on now to the section 9 point. I can just organize these.
The which point? The
new point, section 9.
Oh, section 9, yes.
which, my lord, you said you would take de bene esse.
Well, by all means, do that now. But are you going to deal with the question as to whether or not there is potential infringement of Section 13?
Well, yes. I mean, Lord, I'm not sure how we're going to do this. I've got a rule. I've got the Section 9 point, and I've got the rule of law point. That these are their new points, and there is some depth to go into. And so I'm not sure whether I'm going to be able to finish today. I'm going to try.
Well, it looks to be highly likely that you're not going to be able to finish today.
Yeah, I'm trying to get through this as quickly as I can, but I don't want to truncate the arguments that I have to make.
No,
And
I don't think you should.
I'll have to.
And if we have to sit next week, we have to sit next week. It's not the end of the world.
Thank you. So, with your leave, the starting point.
Oh, wait a moment. That being so, is it sensible to go to the Section 9 point when we haven't exhausted the Section 13 point?
Well, my lord, I think I'd like to take some instruction on that point. And I don't want to stop. I don't want to stop my submission now because I want to know how it was put below. I hear what Mr. Myers is saying. I want to be quite sure. I'm talking to Ms. Sadler-Best, who is out of camera shot, and asking her questions about how it was put because I want to be quite clear.
Okay. All right. Well, take
How it
you
was put.
take of course.
Because I wasn't counsel below, so I need to find out exactly how this was argued below. So, Lord, the starting point for this argument on Section 9 is to look at the summons and the actual supplementary ground.
Yes.
I don't know where you have that. I just have it at the back of the second binder of the record. I'm not sure where you have it.
Well, I printed it out yesterday.
Right.
It had been sent to me by email.
Right. So what we need to do, Lord, is try and interpret exactly what this ground means and what relief it is seeking. It reads, the proposed Reform Act infringes Section 9 of the Constitution, being an unjustifiable and disproportionate violation of the right to free expression. But this is where the problem starts, in that its purpose and effect are to stifle the opinions, not of the corporation, the party before the court, but the electors of the Corporation of Hamilton, by removing not the corporations, but the electors, their long-standing opportunity to express, again, not the corporation, but the electors' views through the regular elections of members of the corporation. So there are two broad problems we see with this ground. One is the evidence with respect to less so purpose, but more so effect, the effect of stifling the opinions of electors of the Corporation of Hamilton. So the evidence of stifling of opinions. And secondly, the fact that nobody whose opinions are purportedly stifled is complaining before the court.
Well, sorry, can you just explain to me? I mean, I can quite see the status problem, but it seems to me that that can be, if necessary and if appropriate, can be easily cured. But the why do you need evidence about effect if somebody's ability to elect a mayor and corporation is taken away? You don't need evidence about that.
But that isn't the charge. The charge that their opinions have been stifled.
But we can decide that as a matter of law. Why do we need evidence from actual individual people? I mean, we read the statute and we make what we make of the effects of the fact that now the mayor and corporation are effectively appointed by the government.
But it may be, my lady, that some people don't believe that their opinions have been stifled.
Well, that's a political decision. That's not.
No, it's a fact. With respect, I submit it's a factual one. They're alleging that there's a stifling of opinions. There's no evidence.
You can't possibly, just a second, you can't possibly get evidence from all the ratepayers and the voters in the city of Hamilton to decide, to express their views as to whether their freedom of expression is being stifled or not. One can't possibly decide it on that basis, because unless you have either an effective sample or everybody, we're not going to know. And that's all political consultation. Now, you may say, well, that's exactly why we, the court, shouldn't be interfering. And that's another point. And I see the force of that. But I don't see myself why you need evidence about this at all. Anyone needs evidence.
Well, lady, this is how they have cast their case, that it's the purpose and effect to stifle opinions. And I think what I think concerns me is that the court is effectively saying you can't have the mayor and the councillors elected in the way that heretofore they've been elected. So that of itself amounts to the purpose and effect of the legislation is to stifle opinions. And in fact, I'm going to take you to some extracts from Hansard, where it clearly said that that is not the effect, and it demonstrates why they should have to file evidence. And the other point we have is that the evidence is controverted. Remember, this is, and I'll come to it shortly, a new point that is supposed to be beyond controversy based on undisputed facts. So this court shouldn't be having to come to findings of fact about the assertions in this ground.
I'm afraid I'm in my usual position of getting confused. There seems to me an infelicity, to put it no higher, in the drafting of the supplementary grounds of appeal, because it asserts that the purpose and effect of the Reform Act is to stifle the opinions of the electors. I don't see how that can, just pausing there, be right at all. I have opinions in my own mind about what my council should do. If you completely changed the composition of the council tomorrow so that it was appointed by the government, that wouldn't stifle my opinion of what the council should do at all. My opinion is in my head. What they actually mean is that they have removed the opportunity to express their views. So in other words, whatever opinion they hold, there is an infliction of, there is an attack on their freedom of expression, because they can't express that view, whatever it is, by means of election. So it's completely uninteresting what opinion somebody holds. If Section 9 is to have any application at all, it's because there has been an inhibition or a prevention of an expression of whatever views the ratepayers hold.
I mean, I'm not sure whether what you're doing is taking out the middle of line 3 through to line 4, save for the last 4 words. Effectively, you're editing what the
Well,
ground.
yes, I am, because although it says its purpose is to stifle opinions, there's no way in which you can stifle somebody from holding an actual opinion. My opinions, as I've said before, which I may or may not express, reside in my mind. So what they're really complaining about is that its purpose and effect is to remove the ratepayers' long-standing opportunity to express their views, i.e. their opinions, through regular elections.
So it then becomes a straightforward municipal election issue. And let me deal with the points that I would have dealt with had we dealt with this in limine, but I'll deal with them now because they are part and parcel of the same argument against this freedom of expression argument in paragraph 3 of the summons.
Yes.
So the submissions, and I note that my lady did mention a way around the standing point, and I think I'll have to address that directly when I hear what that is. But the first point is that by letter dated the 22nd of October, we wrote to my learned friend, Mr. Myers, in response to the summons. And on the second page of that letter, we set out 3 points that we say were arguments against that freedom of expression argument, 1 being allowed to be heard, and 2 substantive points as well. The first was that Section 9 argument is not a point of law as suggested in the summons. We submit that
So where are we looking at?
I have a letter that should be behind the summons.
I got the letter, but I didn't have the words that you spoke, Mr. Duncan.
Paragraph 2, page 4. Sorry. Paragraph 2, page 4.
Page 4.
So, sorry. Page 2, paragraph 4. Sorry. Page 2, paragraph 4.
Right. Please be advised.
Yes.
Yes, right.
Yeah, we set out the 3 points of challenge. Firstly, that this is not a point of law, as suggested in the summons. The appellants will necessarily have to establish new facts to allow on this new round of appeal. So there are no facts that are admitted or proved beyond controversy. In the appellant's letter of the 21st of October, they state that we will in particular be relying on such evidence to demonstrate the suppressive objects of the proposed Reform Act. So again, my lord, I'm not sure whether you're going to recast and ignore that part of what they say is their ground of appeal, but they are relying on suppressive objects, evidence of suppressive objects of the proposed Reform Act. Secondly, the Section 9 argument, had it been raised at first instance, would have entitled the government to adduce evidence to demonstrate that the measures were reasonably required. Now, I'll come to their skeleton argument because they address this issue, but just suggest that we don't need that evidence. They've told us that in their view, we don't need that evidence. And thirdly, is the standing point. The appellant does not have standing to bring the Section 9 argument on behalf of the ratepayers. So look, if I can now take you to their skeleton argument, the appellant's skeleton argument in this appeal, paragraphs 141 to 151. This is where the argument is raised. Paragraph 143.
Yes.
As set out in paragraph 38 of the judgment, the government justifies this measure as establishing a more closely cooperative relationship with central government. However, as is documented in the record, the prevailing motive for the disenfranchisement of the government's existing electors is to still their voices and to override their policy preferences. So, my lord, I see that you're recrafting what the ground is, but that isn't how it's being put. Our submission that this is a clear violation of Section 9, being a disproportionate and unjustifiable infringement of free expression. The notion of more cooperative relationship with central government is a euphemism for, and here we have the words, more obedient relationship under central government. So this isn't about voting, it's about, as they put it in their ground, the effect and purpose is to stifle opinions. They go on in 145. Our submission is that the contravention of the Constitution lies in the removal of an extant democratic mechanism on the ground that its decisions and opinions have offended or are likely to offend an opposing party now in government. It is an attempt to stifle dissent, which significantly impedes the marketplace of ideas, that underlies the principle of free expression, which is a cornerstone of any democratic society, properly so called. They refer to a judgment of Lord Steyn in the case of Sims. And then in paragraph 147, in the present case, it is clear that a primary motive behind the disenfranchisement of the electors of Hamilton is effectively to suppress their political opinions as reflected through their representative members, which are channeled into the policies of the corporation. To be blunt, the disenfranchisement and its appointed alternative constitutes a device to stifle views that are not trusted. It is true that members of the corporation will be replaced, but they will be replaced through a control system of appointed members. Whatever the reality turns out to be, this measure surely raises a powerful presumption appearance of top-down suppression of inconvenient local opinion. Paragraph 149. Insofar as it may be argued the right under Section 9 may be limited under Section 9(2)(a) if reasonably required in the interest of public order, our response is that public order is not a justification for these measures, which are in any event not reasonably justifiable in a democratic society for the reasons adumbrated in the case of Sims. 150, the measures taken as a whole are also disproportionate in that if the present electoral system is considered deficient in a way that has been alleged, i.e. by according too much weight to business ratepayers, and my lord will recall from the evidence that up to 1978, only landowners could vote in the elections. And then there was a short interregnum when the rights of residents were reflected and they could vote. But one of the reasons there is concern is that the fact that the appellants, we understand, seek to reinstate the business vote. Then a less intrusive measure could be provided, such as to return to the provisions of the 2013 amendment, which—
Mr. Duncan, I thought the business vote had already been reinstated.
Yes, it has. But one of the things that is of concern is that it's not fair to the residents. It's not a fair balance between the residents and the business vote.
Right.
That's one of the concerns. So, Lord, that's how they put their appeal. So we are seeking to challenge their right to proceed with this appeal on the basis of the way that it's framed. And I don't think we can challenge it on any other basis. If the court is saying that there is a different basis, that's certainly not the basis upon which we understand the case to be put.
Yes. Well, I see the force of that. I mean, the trouble is this, what might be regarded as hyperbolic expression of case. I'm just thinking aloud at the moment, may be wholly unnecessary. What you say, understandably, is what's being said against us is that the government's justification isn't worth the paper it's written on, and that the real motive is to still the voices of existing electors and override their policy preferences. You say that if we've got to consider what's the motive of those who put forward the legislation, we can't do that on the basis of statements in Scullin arguments.
Lord, we say that at this late stage, that's the basis upon which they put their case. If the court is going to consider it, they're stuck with that. That's what we've prepared on that basis, and now it's going to be changed again. I mean, and I'll go to the issues of the evidence and the lateness and standing, but that's how they put their case, and they are stuck with that in this application. And it is not a case, as my Lord, if I can use this word kindly, tried to edit the ground of appeal. That is not what their case is. And so we say, based on the case they have, our arguments with respect to evidence being in dispute, standing, and reasonably required are significant points that should suggest to the court that this matter should not be allowed to proceed. And we will come to that in detail. First, my Lord, if I can ask you to look at paragraph 6 of the skeleton argument entitled Skeleton Submissions of the Respondent in relation to the summons dated 7th of October.
Yes. Just a moment. Yes.
Now, Lord, I know that you've been bindered into oblivion, but there is another binder called Appellant's Authorities for the summons dated 7th of October.
Yeah.
That contains 2 authorities that I'd like to take you to that are referred to in paragraph 5 of the skeleton argument I've just drawn your attention to.
Moment. They on the cloud. Yes, they are.
Which are the cases I have?
5. It should be 5. The first case,
Right.
is, well, you should have a case called Connecticut Fire Insurance.
Indeed.
Yes. Can I ask you to look at, we can go straight to page 480. The facts aren't relevant. The principle, what we can glean from the case. Paragraph 1 at the top of the page. When a question of law is raised for first...
Hang on.
Sorry.
Just me. Which page?
480.
Right.
When a question of law is raised for the first time in a court of last resort upon the construction of a document or upon facts either admitted or proved beyond controversy, it is not only competent but expedient in the interest of justice to entertain the plea. The expediency of adopting that course may be doubted when the plea cannot be disposed of without deciding nice questions of fact in considering which the court of ultimate review is placed in a much less advantageous position than the courts below. But their lordships have no hesitation in holding the course ought not in any case to be followed unless the court is satisfied that the evidence upon which they are asked to decide establishes beyond doubt that the facts, if fully investigated, would have supported the new plea. To accept the proof adduced by a defendant in order to clear himself of a charge of fraud, as representing all the evidence which he could have brought forward in order to rebut a charge of negligence, might be attended with the risk of doing injustice. So the first portion of that paragraph contains the basic principle that is relied upon in my learned friend's letter of the 7th of October accompanying the summons. But a more helpful case is the case of SGCA 2020, a Court of Appeal of the Republic of Singapore decision. So
Is this
that's
the second?
I have them tabbed 1 to 5. This would be my 5th, so it may not be your 5th, but it's the case SGCA 68, and it's JWR Limited versus Edmund Pereira Law Corporation.
Right.
Yes.
If I can ask you to look at paragraph 29. They set out that new points were related to the probative value.
Just a moment, Mr. Duncan, haven't got to paragraph 29
Lord,
yet.
I do apologize. Normally I go at a more temperate pace, but I'm looking at the clock and I'm trying to get as much.
Right, well, I think my lord's dealt with that. Paragraph 29.
Yes.
Yes.
Right. So paragraph 29, the new points on appeal related to the probative value of an offer by a third party in the context of valuation exercise, not necessarily that relevant, but the principle is found in the case that's referred to Cecil Awati, and it summarizes the principle starting at paragraph 47. Arguably, the most frequently cited and authoritative rendition of the principle governing the introduction of a new point of law on appeal is that expressed by Lord Herschel in the House of Lords decision of the owners of the ship Tasmania and the owners of the freight versus Smith and others. A point such as this, not taken at trial and presented for the first time in the Court of Appeal, ought to be most jealously scrutinized. The conduct of a cause at the trial is governed by, and the questions asked of the witnesses are directed to the points then suggested, and it is obvious that no care is exercised in the elucidation of facts not material to them. It appears to me that under these circumstances, a Court of Appeal ought only to decide in favor of an appellant on a ground they are put forward for the first time if it is satisfied beyond doubt first that it has before it all the facts bearing upon the new contention, as completely as would have been the case if the controversy had arisen at trial, and next that no satisfactory explanation could have been offered by those whose conduct is impugned if an opportunity for explanation can be afforded them when in the witness box. Continuing with Lord Birkenhead, there are very few cases which can be confidently stated that failure to raise a relevant contention at the appropriate stage will not prejudice the other litigant. I desire to draw attention to a consideration which in my view is both more general and more important. To acquiesce in such an attempt as the appellants have made in this case is in effect to undertake decisions which may be of the highest importance without having received any assistance at all from the judges in the courts below. It is axiomatic that the interests of justice must be afforded a wider scope than just merely to encompass one party, i.e. the appellant's expectation of justice. It has to be emphasized that finality in litigation is usually as much in the interest of justice as a party's interest in succeeding in its claim. The legitimate expectation of the respondent here are that the case should be resolved on the basis of arguments presented and evidence adduced in the court below, and not on newly minted arguments that require further testimony and forensic examination. Plainly, there will be a grave and altogether understandable sense of palpable injustice felt by a respondent if a verdict is reversed on grounds that ought to have been raised earlier and could have perhaps been addressed by contrary evidence at the trial.
Yes.
So that is the authority we would seek to rely on. We say that there is evidence based on the way the case is currently put, the way the appeal is put, what we would have adduced with respect to the allegations contained in paragraphs 141 to 150 of their skeleton argument. That is how they put their case. And for them to suggest now, conveniently, that isn't how they put their case, leads us into another position. Well, how do they put it, and how do we deal with that? It's like a moving feast and a moving target. Paragraph 6 of the skeleton argument, if I can come to that, we come to another point now. Based upon the case put by the appellant before the learned Chief Justice, the rationale behind the Reform Acts was not relevant. Argument concerning protection of the law was only relevant to the issue of consultation, which, as I said earlier in my submission, has now been abandoned. So the learned Chief Justice was deprived of an opportunity and actually did not make any findings as to the rationale behind the effect of the Reform Act or the bill. Paragraph 7 of the skeleton argument, the appellant recognizes that the government's justification for the measure is a more closely cooperative relationship with central government. This echoes what the learned Chief Justice said at paragraph 38 of the judgment, and I have quoted that paragraph. However, paragraph 8, what the appellant is in fact asking the Court of Appeal to do is to go beyond what the learned Chief Justice was being asked to do at first instance and make findings that the appellant needs to properly advance the Section 9 argument. What's more, the appellant asked the Court of Appeal to do that based on the appellant's expressly contradicted evidence. By that fact alone, the facts needed by the appellant to make the Section 9 argument cannot be said to be either admitted or proved beyond controversy as the test sets out. And in paragraph 9, we identify some of the contradictions. A, paragraphs 46 to 52 of the affidavit of Rosie Azar set out the rationale for local government reform and states, for example, at paragraph 52, the two levels of taxation and the segregation of authority between the municipalities and central government, while necessary in larger jurisdictions, may not be justifiable in a geographic area. If I can ask the court to look at that, and that is at page 545 to 546 of the record. The reason why it's important to look at that is because one of the considerations the court may have in mind, and I haven't yet developed this, and I'll need to take instructions, but based upon the questions that were being asked with respect to the taking of property, one of the issues may be what is the purpose behind that, and if it satisfies a particular purpose under Section 13, then we've seen from the cases of Campbell Rodriguez and Panton that that may not amount to a taking under the legislation. So at what we have is, if I can just introduce this properly, what we have is the affidavit of Rosie Azar, and there are references to ongoing issues between the corporation and the government. At paragraph 36, page 542, there was a creation of a trust over the corporation's property. And I think that if you look at paragraph 36, you see reference to the Ombudsman's report about the concerns that were expressed about how the corporation's property was being managed and handled by the mayor and the councillors.
Has that transfer taken effect and is still in force?
Yeah, it's returned. I'm instructed the property's been returned.
That's what I thought.
Yes, but Lord, you know, one has to wonder whether this is, I mean, there are accusations being made against the government. One has to wonder whether this is the kind of conduct that the corporation wants to be free to exercise in future. And then
Just a minute, I wonder if we can cut this short. You say in these paragraphs, ending with paragraph 9, that if the question is what was the, amongst others, what was the motive for the government acting in the way that it did, that's not a matter that we can possibly determine. It wasn't determined by the judge below, and we can't do it on the basis of conflicting evidence, which is documentary. That's what you say.
yes, and the reality is that we, the government, have lost an opportunity to have called that evidence in this instance.
Yes. Well, I mean, speaking for myself and without consultation of my colleagues, that seems to be so. On the way in which it's put in the skeleton argument. In fact, since what is relied on is section 9, which is that the right of expression has been curtailed, and since the way in which it's put is that the freedom of expression has been curtailed because the ratepayers, electors, can no longer express their views by voting, if the bill gets ahead, by voting. That itself, if that's the way to which it's limited, doesn't require any evidence at all. Because if that is so, if that's a good point, the election, the cancellation of the right of election by electors will necessarily have the effect that they can't express their view, if it is an expression of view, as to who they want to represent them.
Well,
the problem with that is that, yeah.
And that was the point I was making, if I may say so, the point I was making about 20 minutes ago. I don't see you need evidence about that. The motive point is quite different. And I quite see your points on the motive, Mr. Duncan, but the basic point doesn't need evidence, and you couldn't get it anyway, I doubt.
Well, certainly the appellants have got what they consider to be evidence in support of it, and we really should have the right to controvert
it. But all that's political, isn't it? It's all what the voters will say or express their views. It doesn't actually go to the point at all. I mean, maybe you've got a good motive, maybe you've got a bad motive. This court can't, indeed the Supreme Court can't possibly decide, because that would be interfering into, the reason why politicians do things.
Right, my lady, but all I can say is that's how they put their case. They don't put it.
Okay.
I hope I'm not ignoring your question, but I'm just dealing with what we're confronted with in terms of how they've put their case.
Yes, well, I see the problem, what you're confronted with, but if this matter is to get anywhere, where what you ought not to be confronted with is that, but with the simple question, to answer to which may not be easy, as to whether or not denying electors a right to vote is an inhibition on their freedom of expression, because they can't express themselves by voting people onto the corporation, I mean, that would have the curious consequence that if the legislature decided that it would abolish a municipal corporation, which presumably it could do since it was the legislature that founded it, it would find itself caught by the inhibition on freedom of expression. But that could be argued. Perhaps you could. I mean, we must stop, I'm afraid, in a moment. But
the one point I just want to leave the court with before I develop it is the point on evidence just doesn't relate to the issue of controverting the ground of appeal as it's currently framed. The evidence point also relates to the issue of whether or not there is standing, the hindrance point. There is no, I'm not sure whether the court is suggesting that, you know, the standing point is not a good point, but the reality is that the way that the ground is drafted, even if you edit it in the way that my Lord the President suggested, the way it's drafted, it still says, and accepting the editorial comments of the President, the proposed Reform Act infringes Section 9 of the Constitution, being an unjustifiable and disproportionate violation of the right to free expression, in that its purpose and effect, well, it's going to have to be to stop. We're going to have to insert some other word or prohibit the long-standing opportunity of and it would have to be electors to express their view through regular elections of members of the corporation. So it's still the electors who are the party who have been, quote unquote, allegedly hindered.
But if the position is that the electors have been hindered because they can't, in the future, elect the members of the corporation, can't the existing members of the corporation take that point?
Well, I didn't think it may sound crass, but they don't have a right to vote. They have a right to be elected. The electors have the right to vote. And
well, the members of the corporation probably do have a right to vote because presumably they're electors.
Well, they haven't brought the case on that basis.
Well, no, but I mean, let's be realistic. They must be electors.
Right. But I mean, effectively what we're doing is reframing the case for them, but that isn't the basis upon which they bring their case. Right now, we have no evidence of anybody being hindered. The way this case would normally have been brought, as this court is well aware, is that normally they would have produced evidence to demonstrate that there is a hindrance, and they would say their rights have been hindered. There's a very low threshold to establish that. And then we would be able to reply with evidence with respect to whether the measures were reasonably required or the legislation.
Now, that's a different point.
Well,
No, this may be in your favor. You say that you would be able to adduce evidence that the measures were necessary for public order reasons. Now, that begs the question as to what the public order exception in Section 9 covers. And we haven't presently got those cases before us, but we were told they only covered things like avoiding a phrase and the like.
Well, Lord, the question is a bit more basic. The question is, when we look at the skeleton argument filed by the appellants in paragraph 149, they know this is an issue. And they realize that bringing this ground now through the back door compromises the way that the evidence would normally be adduced under Section 9(2)(a). But they then tell the court, don't worry about that. There is no evidence that would be satisfactory. It's all there. That is a totally unfair way to approach advancing this new ground of appeal. paragraph 149, insofar as it may be argued that the right under section 9 may be limited under 9(2)(a) if reasonably required in the interest of public order, our response is that public order is not a justification for these measures, which are in any event not reasonably justifiable. There is evidence that I haven't gone to yet in Hansard that sets out clear reasons why, candidly, my lords, both political parties want these provisions in place. And I need to go through that in some detail. Both political parties want this in place. There are comments from the OBA and comments from the PLP. So despite the fact that this is tinged with an undertone of politics, it is apolitical in terms of those who want these provisions in place.
Right. Well, we will have to think about how we proceed in relation to section 9. I think we must adjourn now. I think we would like to be provided with the authorities to which we were referred but not shown, to the effect that the public order exemption is of limited reach. I think it would be necessary to see those. Because if, for instance, they say that you only come within the public order exception if you need to curtail freedom of expression in order to prevent a fight, then the relevance of what people say in Hansard would be non-existent. So can we be provided with those? And could we also be provided with the authorities referred to in Hansard in relation to, the authorities Halsbury in relation to the effect on the ratio of a decision of the fact that there's an appeal to the Privy Council, which proceeds upon a different basis.
Certainly, my lord.
So we will have to adjourn until a date next week. It's quite likely to be Wednesday afternoon, though not certain. We have it might be Thursday, it might be Friday, but we will have to fix that in the usual course of things. And we may give further directions before then. Right.
My lord.
Thank you, my lord.
Thank you, my lord.